procurement roadmap guides the way forward by considering local business capacities, climate, environment, health, and value for money. Our government procures thousands of items every year to serve the Filipino people. When government is the single largest buyer in a market, its procurement decisions influence the direction that businesses take. Green public procurement is about buying products which are low carbon, are healthier, avoid harmful chemicals, and are manufactured through cleaner processes. They are efficient to use and consume less energy and water. At the end of life, precious materials are recycled. GPP reduces the pressure on the environment. GPP is a partnership between the government and businesses. GPP opens up new, exciting, and reliable opportunities for businesses supplying green products. This in turn makes green products also affordable for private households. A first batch of 20 product categories has been prioritized for GPP, and more will be selected over time. The priority common supplies and equipment products are multi-copy paper, toilet paper, record books, cleaners, chairs, disinfectant sprays, trash bags, liquid hand soap, detergent powder, and LED lights and bulbs. The priority non-common supplies and equipment products are computer and laptop monitors, air conditioners, vehicles, fridges and freezers, copiers, paints and varnishes, food and catering services, training hotels and facilities, toilets and urinals, and textiles such as uniforms and work clothes. The well-established public procurement processes in the Philippines, such as the PhilJEPs, will ensure fairness, transparency, and open competition for the green venture. Everyone can become an active consumer of green products, which save energy and water, are not harmful for health and climate, and which are recyclable.
Do you know that procurement is crucial in achieving our society's collective vision of a strongly rooted, comfortable, and secure life in the Philippines? Hello everyone, I'm Billy Bayong. Let me show you how our Procurement Policy Board innovates, adapts, and responds to our changing needs to enhance the procurement system and help the government work for us. An efficient, transparent, and competitive procurement system connects every Filipino to vital services from the government. This can help move more people out of poverty, gain access to better education, receive quality healthcare, and enjoy economic opportunities. These yield greater trust in government institutions and bring the country closer to achieving its national development goals. The Government Procurement Policy Board focuses on simplifying various processes to produce more successful procurement that contributes to the effectiveness and efficiency of the government. The board employs strategies to identify needs and implement projects. It refines and calibrates procurement policies, adjusting to emerging trends based on needs of procuring entities. It creates ways to capacitate practitioners to better manage their procurement processes, monitor effectiveness of our procurement systems, and it adapts to the times, especially during national emergencies. The GPPB has strengthened the procurement process at the earliest stage, the planning phase. The board has issued bidding rules responsive to new laws and policies set by the government. GPPB has also streamlined the bidding process through the use of technology. GPPB has introduced guidelines to ensure timely procurement, especially during a national emergency. GPPB Technical Support Office pioneered initiatives to better assist procuring entities. Simple and competitive, transparent and accountable, monitored by the people. These make for an effective procurement system. responsive to the needs of the people. The GPPB, adapting, responding, innovating for nation building. To know more about procurement, visit gppb.gov.ph.
An extravaganza morning, and thank God it's Friday. Welcome to the fifth batch of the online training on Government Procurement Reform Act, or the Republic Act number 9184, and its 26 and revised implementing rules and regulations for the municipal local government units. Brought to you by none other than by the Government Procurement Policy Board Technical Support Office. And for the last time, I am Maluka Agbay from the Capacity Development Division, is still slaying on the last day of our event. To start our today's program, may I request everyone to put ourselves in the most mighty and holy presence of our Lord Jesus Christ. Loving Heavenly Father, we come to you this hour asking for your blessing and help us as we gather together. We pray for guidance in the matters at hand and ask that you would clearly show us how to conduct our work with a spirit of joy and enthusiasm. Give us a desire to find ways to excel in our work. Help us to work together and encourage each other to excellence. We ask that we challenge each other to reach higher and further to be the best we can be. We ask this in the name of our Lord Jesus Christ. Amen. Once again, a blessed Friday morning to everyone, especially to the Facebook Live viewers. Okay? But to jumpstart our energy, we will be having another morning activity. And this is the guess the movie title. So the game mechanic is very simple. We will be flashing on screen a clips of our very own original Filipino movie, and all you have to do is guess the movie title in 5 seconds. For those on our YouTube and Facebook viewers, good morning po. You may still join our morning activity by posting your answer at the comment section. So without further ado, I think ready na lahat. But before we flash the first siguro, can I have your ready react from our participants? Okay, kahit anong emoji pwede yung gamitin kung ano ba yung nafe-feel nyo this morning. Is it feel love or feeling okay lang or light? Ayan. So thank you. I think ready na po ang ating mga participants. So let's flash the first movie clip.
Sana, tuwing umiinom ka ng alak, habang iniitip mo ang sigarilyo mo, habang nilulustay mo yung mga perang pinadala ko, sana maisip mo rin kung ilang pagkain ang tiniis kong hindi kainin para lang makapagpadala ko ng malaking pera dito.
Okay, so what's the answer? And the answer is anak. Tama po si Sir ulit from Digos. Talagang ibang breakfast sa Davao del Sur. Thank you for joining. Lahat naman ang sumagot are correct. Okay? So for the next movie clip.
Kahit saglit lang. Kahit isang gabi lang. Pahiram ng asawa mo.
Ayan. So parang dito medyo natigilan ng mga participants. Parang mas makakasagot siguro ito ang mga babae. Pero sige, let's have time para makasagot pa ang iba. Starring ito ni Angel Locsin and Angelica Panganiban. Ano kaya ang sagot dito? Can we flash the correct answer po? What is the movie title? Ayan, sorry pero hindi po between the two of us. So may humawal pa nga, The Mistress daw. Ang correct movie title po ay One More Try. So again, try ulit tayo, one more try ulit tayo for this next movie.
You're nothing but a second rate. Trying hard. Copycat.
Alright, you can answer na po. Ito po ay napaka-iconic movie starring our very own Sharon Cuneta and the late Sherry Hill. So, what's the correct movie title? Ayan, bituing walang ningning. Congratulations po ulit from Davao del Sur, si Ma'am Cecilia Habao-Bao. Alright, I think we have one last shot ng movie.
She loved me at my worst. You had me at my best. At pinali mo naman ang lahat yun.
Gumaling mo talaga yung tingin mo. I just made the choice.
And you chose to break my heart.
Ayan, so sino kaya ang mga fan dito ni John Lloyd and Bea? So may mga sumagot na po. Marami is One More Chance. Is this the correct movie title? Ayan, congratulations po, Miss Kay Ann from Catanawan, Quezon. And for the rest, tama naman po lahat ng sumagot. Medyo mas mabilis lang ng konti si Miss Kay Ann. So I think meron pa po bang isa na movie title?
Yes, ako. Kaibigan mo lang ako.
Ayan. So, ito po ay pinakasikat na love team, parang Katniel ng 90s. So, dun sa mga, 90s babies, sana makasagot kayo. Ano kaya po itong movie title na to? Ayan, loves kita, okay ka lang. I hope okay lang ang ating mga participants kahit hindi nakasagot ng tama sa ating last movie title. Alright, this is the last na po. Okay, I hope that we already enabled to activate and fueled our mental cognizance this morning. And now, at this point po, before we shift to the actual lecture, as promised, let us first have our early bird winners for today. So for the first early bird winner, congratulations po from MLGUS Salcedo Ilocos Sur, Miss Florencia B. Almares. And for the second early bird winner, from MLGUS Salcedo Ilocos Sur pa rin po, Miss Catherine Zane N. Almeda. Congratulations po once again, and our event secretary shall coordinate with you on how you may claim your special token. So please check na lang po ang ating mga chat messages. Also, for all previous winners of our program, please do check your emails or chat box too, and kindly revert back with the details for us to ship your respective tokens. For today's activity, I am particularly excited because we will be tackling about the penal, civil, and administrative provision, and will be followed by our last session focusing on the protest mechanism and remedies and blacklisting guidelines. Please do ready your e-game as we were going on our final stretch of our learning activity. With that, allow me to introduce our research speaker for our today's session. It is my pleasure to introduce our research speaker. He graduated with a Bachelor of Science in Agriculture, major in Agronomy at Xavier University Ateneo de Cagayan, and Bachelor of Laws at the Father Saturnino Urios University, and obtained his diploma in Masters of Dispute Resolution at the University of Technology in Sydney, Australia. He is a trained specialist on local legislation, ordinance codification, and administrative investigation and procurement law. He is also the man behind the books The Local Government Code of 1991 as amended with Supreme Court decisions and DILG options, as well as the Barangay Governance for Peace and Development funded by Act for Peace program. Aside from being instructor in remedial law, review, civil procedure, intellectual property law, and alternative dispute resolution College of Law at the Padre Saturnino Urios University College at Batuan City, he is also a research speaker in different seminars, trainings, and workshops on local legislation, local governments, conflict management, procurement law, real estate, revenue generation, and many others. He is also a recognized trainer of the GPPB and currently the presiding judge of the Municipal Circuit Trial Court of Habonga, Quicharao, Agusan del Norte. So without further ado, ladies and gentlemen, let us all welcome our speaker, Judge Anthony P. Vitor.
Good morning, participants, to this online training on Government Procurement Reform Act or the Republic Act 9184 and its revised implementing rules and regulations, especially to the participants from the different municipal local government units of the country. So I am your resource person for today. I am Anthony Vitor, and I am discussing to you 3 topics for today. It's about penal, civil, and administrative liabilities, termination of and protest and blacklisting mechanism. So I'm sharing my slide and discuss first the penal and civil liability. Okay. So as we know, if we government officers or public officials committed criminal act, we are liable, what we call threefold liability. We are liable civilly, criminally, and administratively. No, that is for us, the public officers. So the standard of ethics in procurement is required to be observed by all participants in the procurement process and up to the execution of the contract. So it should be observed by the procuring entities, specifically in this particular training, the local government units, the bidders, manufacturers, suppliers, or distributors during the procurement and execution of contracts, and any bidders who have committed corrupt, fraudulent, collusive, and coercive practices by the government will not be eligible to bid in its project. So there are 4 unlawful acts. Coercive practice, meaning threatening to harm the other person in order to influence the outcome of the bidding. Collusion, again, the 2 or more persons agree to make any arrangement, whatever, to have the bidding be favorable to this particular bidder or disadvantageous to this particular bidder. Then corrupt practices, of course, the giving of consideration, whether in kind, money, or whatever, to a certain person involved in the procurement, in order to, again, influence the outcome of the bidding. Fraudulent practice, when when a person or the bidder or any person involved in procurement would make a mispresentation of documents, again, to influence the outcome of the bidding. So what are the penal provisions? The Republic Act 9184 states that it is without any criminal act committed in violation of 9184, it is without prejudice to the provision of RA Republic Act 3019 or Anti-Graft and Corrupt Practices Act. Meaning, if you committed a criminal act in violation of 9184, for as long as the elements are also present in violation of RA 3019, then you are, or a person who committed an act in violation of 9184 may be also be liable under RA 3019 or liable under criminal law or revised penal code pertaining to by bribery, direct bribery, or indirect bribery. Okay, so it is without prejudice, no? So meaning, ano lang, it's because I violated only 9184. No. Even if you are already criminally charged for violating RA 9184, you may still liable under RA 3019 for as long as the elements of R 3019 or provisions of that R 3019 is present. Okay. So who are those liable? So liable are those public officers who committed any of the acts enumerated under section 65.1 of the IRR, and the private individuals who collude with the public officers. With regards to 65.2 and 65.3, or violations of sections 65.2 and 65.3, it is committed by private individuals. But the public officers who conspires with the private individuals are also liable. So in both instances, whether you are public officers in collusion with private officials or private officials or private individuals in collusion with public officers, liable pa rin. Okay. So this covers all types of procurement, whether done it is manually or electronically, no? Because we're already allowed to because of 91 pandemic, COVID-19 pandemic, we are already allowed to conduct procurement electronically. However, pertaining to criminal liability, no, if when the bidder is a juridical entity, a criminal liability and its accessory penalty shall be imposed on its directors, officers, employees who actually commit any of those acts under section 62 or section 63, section 65, who actually committed any of the foregoing acts. No? So if it is a corporation or cooperative, then it is the person who actually committed any of the foregoing acts are or is liable. Diba? Of course naman, the personal liability yan dahil hindi, you cannot imprison a juridical entity. You cannot imprison a corporation. You cannot imprison a cooperative. You can put in prison only the person. So it's not juridical entity, no. So because you cannot imprison a corporation. Only the person or officers, employees who actually committed any of the foregoing acts. So we'll discuss what are those foregoing acts. No. So if a person previously held liable or found guilty under the provisions of this act and this IRR has a controlling interest in a prospective bidder entity, the said bidder entity shall be disqualified to participate in any procurement activity being conducted by the government. So if this particular person has a controlling interest of Corporation A, 20%, he owns 20% of the shares of that particular corporation, blacklisted. So if there is also Corporation B, in which this person who has controlling interest in Corporation A has also a controlling interest in Corporation B, that Corporation B is also disqualified or blacklisted to participate in any procurement activity. So that's it. So there must be a controlling interest, which it's 20%, at least 20% of the controlling shares is owned by that particular person. Okay. So what are the penalty? What's the penalty in case of imprisonment? So the imprisonment is 6 years and 1 day, but not more than 15 years. So an imprisonment is 6 years and 1 day to 15 years. So there is no because this is special law. There is no opportunity to apply for provision. No? Because provision is only applicable if the penalty imposed is not more than 6 years. No? So 6 years. So provision is not available if you committed this particular offense. Maybe if during the trial you apply for plea bargaining and you will apply to play on another law or the same which has lower penalty, then you may, but it depends on the court whether to grant, or depends on the prosecution, the parties to grant, whether to grant the plea. Okay. So with regards to public officials, so penalty, this is an accessory penalty, no? So aside from 6 years and 1 day imprisonment, but not more than 15 years, accessory penalties, temporary or perpetual disqualification from public office. So temporary disqualification is during the period of imprisonment, you are not allowed, you are prohibited from whether elected the appointment position in the government. That is temporary. Perpetual disqualification, of course, whether you're already released from prison because you already served the sentence, or because of good conduct allowance, your imprisonment is shortened, then you can be appointed or elected in a public office. That is for temporary disqualification. But perpetual meaning hanggang mamatay, wala na pong opportunity to be in the public office. With regards to private individual, diba, juridical, because what can be imprisoned for juridical entities only the person who actually committed the offense. So that person who committed the offense, because he's the one who is already imprisoned, then that person is permanently disqualified from transacting business with the government. So that person is what? Blacklisted already, disqualified. Okay. Jurisdiction over the offenses defined under this rule shall belong to the appropriate courts according to the laws existing at the time of the commission of the offenses. So remember, it's 6 years and 1 day to 15 years. So in this particular case, if the offense is in violation of 9184, it should be filed before the regional trial court. Because the regional trial court has jurisdiction of any offenses in which the imposable penalty is at least 6 years and 1 day. But if the person who committed the offense, the principal, especially the principal, has a salary grade of at least 27, then it should be filed before the Sandigan Bayan. Under the law creating the Sandigan Bayan, even if you do not belong to SG 27, you are still, the Sandigan Bayan has still jurisdiction if, especially in the local government units, if you are a provincial governor, provincial vice governor, sangguniang panlalawigan, and head of offices of provincial head departments, provincial engineer, whatever. and also to the city mayor, city vice mayor, sangguniang panglungsod, and city department heads. So their cases should be filed before the Sandigan Bayan. No. But even if you're not included in this particular enumeration of the law creating the Sandigan Bayan, if one of your principal, if the principal, if or one of the accused is, I mean, the case against one of the accused is filed before the Sandigan Bayan because it's covered under that law, no? So those persons who are not receiving or not within SG 27, or he's not the mayor or the head of office, pero kasama kayo sa act, then your case should be filed before the Sandigan Bayan. So just like sa example sa LGU, the Bids and Awards Committee, what is required is only the third level should be the chair of the BAC. But the members of the BAC, it is not required. Diba? Kailangan office, sinasabi lang from the office of the budget, municipal city budget office. So anybody in the budget office can be a member of the BAC, not necessarily the budget officer. So of course, that person has a salary grade of less than the department head. But since accused kayo lahat as BAC, yung head ng BAC third level sa city, or kasama yung city mayor, then lahat yan Sandigan Bayan. Okay. Hindi pwede yung si mayor lang ang Sandigan Bayan, si city head department lang ang Sandigan Bayan, dahil ako I belong to the salary grade below 27 or below that of the department head. A case should be filed against me before the regional trial court. Hindi yan pwede. Doon sila lahat sa Sandigan Bayan. So what are the offenses committed by public officers under Section 65A of 9184? First is open any sealed bid, but not limited to bids that may have been submitted through electronic system. No. So kahit pa electronic system, electronic yung pagpadala ng bid, no? Kailangang dahil yung open naman ng bid sa electronic, dapat may mga password. Okay. Now, kung i-open mo yan or you receive open documents, then you are liable. So kung open documents kasi na nasubmit sa inyo, naka-open yun, do not accept. No? Secretariat, do not accept. Let the bidder or the one who submitted the bid docs to seal the bid. Do not touch, do not accept. Now, if it is improperly sealed, no, na-seal po siya but not full or improper, no, then you can accept that, but they have to notify the one who submitted the documents, no, that this document is improperly sealed, no. Naka-seal siya pero naka-seal pero may mga problema lang, pero di mo rin ma-open, no. So dahil if you accepted an open bid, or you accepted or you open it, then you are liable. Secretariat, you're liable under this law, no. So do not open. Then second, delaying without justifiable cause, the screening for eligibility, opening of bids, evaluation and post-evaluation of bids and award of contracts beyond the prescribed periods of action. So, di ba sa pag-post ng invitation to bid or yung sa consultancy, nakasad na doon when to open the bid, when to screen eligibility, when to post eval and award of contracts beyond the prescribed period, di ba? May mga dapat this number of days lang may award ng contracts na. That is without justifiable cause. No. So you are liable, back members liable under section 65A of RA 9184. But nakasad naman dito without justifiable cause. Example, kung ang schedule of bidding mo is schedule of opening of the bids or screening of eligibility naka-schedule, lindol, may typhoon just like what we are experiencing in Manila. Okay. May typhoon, nag-declare ang president walang pasok, nagkataon yun ng opening of the bids. Syempre, you have to cancel your opening of the bids because the delay is justifiable. So may justifiable cause yan. So pwede yan, you are not liable. No? Ang ano lang dito, without justifiable cause. Then, next is undue influencing or exerting pressure on any member of the BAC or any officer or employee of the procuring entity. So unduly influencing or exerting undue pressure. No? Example, may mga ano tayo, example, especially sa LGU, di ba? Yung mga ano, member. Example, mga member doon hindi pa promotable. Okay, sabi ng mayor, sabi ng back chair, dapat gawin mo to, dapat ganito, dapat ito yung mananalo, dapat di ito ma-award sa ganito na bidder. Dahil kung hindi mo, you will not follow my instruction, remember, Mr. Back member, Mr. Back chair, you are promotable, your appointment is already in my desk, and you know, if you will not follow my instruction, or I may not appoint you, I will not promote you. So that is unduly influencing or undue pressure or exerting undue pressure. Again, splitting of contracts. Well, splitting of contracts, the purpose is to avoid competitive bidding. Avoid competitive bidding. So example, nandoon na yung budget. The budget is more than 1 million, example, then that is under competitive bidding, or you want even it is 500,000 but competitive bidding, or example 2 million should be under competitive bidding, but you would split that so that pwede ka nang magpunta doon sa small value procurement. Okay, diba? Municipalities up to 200,000. Okay, example sa munisipyo, mga municipalities may 1 million, you want to split that in order to conduct small value procurement. Maximum is 200,000. Okay. So, 200,000 ba? Tingnan natin. 200,000. So, you want to split that into less than 200,000 so that you can conduct small value procurement. Okay. Dapat ito multi-purpose building. You have to establish first or construct first the roofing. Okay, that is another RFQ because you're conducting small value procurement. Then another is concreting of the floor. That's another small value. No, so that is splitting because the budget is already there. But with regards to something like by parcel, I mean, ano ba yung tawag na yun? Lot A or lot 1, lot 2. Okay. You can do that, no? Because based on your market study, no entity or bidder can supply all of this. So, example, this particular machine can only be supplied. Example, machine A, B, C. No, based on your study, no person, no entity can bid all three, can supply all the three. So only some can supply machine A, some can supply machine B, some can supply machine C. So what we will do is to bid it by lot. No, lot 1 for machine A, lot 2 for machine B, lot 3 for machine C. So you can do that. No? Because based on your market study, failure pa rin kung yung tatlong machine ibibid mo as one, magka-failure pa rin because no one can supply that. So, ini-split mo A, B, C. You can do that. No? You can do that. In the head of the agency abuses the exercise its power to reject any and all bids. Di ba? Sa invitation to bid, may ano doon, may reservation clause. The reservation clause is ito. The head of the procuring entity has the right to reject any and all bids. No? So, kung i-reject kasi, no, dapat may reason. Ba't ni-reject mo? No? Hindi pwede, I don't reject that. Or example, you found out that the PAC did not or abused its power and did not, the bidding was not in accordance with the law or the IRR of 9184. So you have to you can reject that. Or the the observer notifies you or notified you in writing that there's some anomaly in the conduct of the bidding. No, so you can reject the bid. No, so do not abuse. If you abuses that power, then the head, especially the head of the procuring entity, be liable under 65 section 65A. Okay, for private individuals, no, again, public officers conspiring with the private individuals are also liable under this provision. Okay, so section 65B of RA 9194. But the principal what's this liable is the private individual. No? Again, including the public officer. So agreement, first agreement and submission to submit bids with pre-arranged lowest bid. Okay. So yung mga private bidders, okay, bidder A, bidder A, bidder B, bidder C. Okay. Mag-ano tayo? Mag-arrange tayo. Ako lang munang mananalo. Taasan nyo yung mga bid price ninyo. Okay. Dapat ako lang mananalo. Ganito, bibigyan kita ng pera, di ba? May mga buyout, something like that. Okay. Then, malicious submission of different bids to through or more persons. No? Isa lang ang may-ari, pero two or more persons yung pagbibid. No? Okay. Pero isa lang may-ari ng corporation, controlling, di ba? May controlling interest. No? Para, of course, siya lang ang mananalo. Agreement to secure undue advantage, no? Okay. Employment, di ba, may kasama pang open bid. Pero yung open bid, wala yung, kung kasama yung public officer, then kasali siya dito. Now, yung iba, yung mga bidder, gano'n lang, magkano yung bid mo? Magkano yung bid mo? Okay. So, that's an agreement to secure undue advantage. Then, employment of scheme disadvantageous to the public. No? Kung ano yung mga sistema nila na disadvantage sa public. Okay, ito yung gagawin natin, ito yung gagawin natin. Ano yung mga quality lang natin. Okay, yun. Okay. So ito yun. Actually, this is only parang ano lang ito sa kanina. No, when two or more bidders agree and submit different bids as if they were bona fide, when they know that one or more of them was so much higher than the other, that it could not be honestly accepted and that the contract will be surely be awarded to the pre-arranged lowest bid. Okay. When two or more bidders into an agreement which call upon one to refrain from bidding for procurement, or which call for withdrawal of bids already submitted, or which are otherwise intended to secure an advantage to any one of them. Okay. Okay. Huwag kang magbibid. Ako lang, 'di ba? Pwede naman isa lang magbibid, no? Ako lang, huwag na. Or before the opening, ako lang ang sabi kasi ni ano, ako lang mananalo, or ako lang magkano sa iyo. Withdraw mo na yung bid. Okay? So, that is again violation. Okay. Ito, when a bidder maliciously submits different bids through two or more persons, ito, in partnership or any other business entity in which he has interest to create the appearance of competition that does not in fact exist to be adjudged as the winning bidder. No? So, sila lang, isa lang ang mayari. When a bidder by himself or in connivance with others employs schemes which tend to restrain the natural rivalry of the parties or operates to stifle or suppress competition and thus produce a result disadvantageous to the public. So connivance with other schemes which tend to restrain natural rivalry, no, di ba? So kung in connivance with public officers, okay. And ang submission is nasa elevator, nasa 13th floor. Pagkapunta doon dapat naka-elevator. Okay. Sasakay ka ng elevator sa 14th floor. So kung ang isang bidder at something like 8 o'clock, submit na yung on or before 8:30 in the morning, submit yung BDOC. So 8:30, nagsubmit na yung isa. In connivance with the public officers, sirain mo yung elevator para hindi sila makapunta dito on or before 8:30. So that is advantageous to the public. Walang competition. Walang competition. So yun ang mangyari. Okay. Submission of eligibility requirements containing false information or falsified documents or concealment of such information. Okay. Actually, this one can be found during post-qual. No? During post-qualification, you can do checking whether requirements are true or false. Then submission of BDOCs containing false information or falsified documents or concealment of such information. Using name of another or allowing another to use one's name. Actually, tingnan na kung ano na, marampan ito eh. Bibi, ano lang ng royalty, gagamitin ko lang yung license mo. Ako lang hindi subcontract. Parang ganun, subcontract pa rin using your license. O bibigyan lang kita ng royalty, magkano bang royalty mo? Okay, ito. Ako lang, no? Ang problema kasi diyan is kung ang trabaho is not good, no? The quality is not good. Of course, yung principal ang liable, di ba? Go withdrawal of bids without justifiable cause, no? Withdrawal of bid dahil ba't palagi kang nagwi-withdraw? I think it's thrice a year, palagi kang nagwi-withdraw. So, red flag na yan, no? Red flag. Now, question is, sinong magsusumbong? Who will complain? Especially in section ito, using name of another or allowing another to use one's name or withdrawal of bid. Okay po. Then itong sa B, sinong magsusumbong? Tayo naman lahat, nagkapera dyan eh. Bibigyan kita ng pera, iba-buy out kita, ako lang magbibid, o magkano bang nagagasto mo, i-refund mo, times 2 ko pa. Okay, ako lang magbibid. Yun kang nabayaran ko na to withdraw the bid. Ano ba? Magsusumbong ba 'yon? I doubt, no? Ewan ko kung ang participant ba nito magsusumbong. Dahil kung if you are not a participant of this offense, of this act, how can you prove that in court? No? Nagbibigayan sila. Paano nagbibigayan? Yung yung mga bidders, sabi walang bigayan, walang binigay in order for me to withdraw, wala. So it's difficult to prove for me. I don't know to others if it is possible to prove in court. Well, with regards to submission of eligibility requirements or submission of false information, well, pwede sila liable dahil kita naman dahil ng, 'di ba? Ang technical working group pupunta mag-post qual so makita nila yung documents.
At this point, we will be having our first knowledge check. So may we ask our technical team to flash the first question. All right, since we're having a difficulty, may we remind na lang po our Zoom participants po that you can start now dropping your questions in the Zoom chat box, as well as in the Facebook live comment section. Okay, so for the first question, Republic Act number 3019 is otherwise known as the A. Government Procurement Reform Act, B. Anti-Graft and Corrupt Practices Act and other penal laws, or C. Anti-Red Tape Act. All right, so while waiting for your answer, we highly encourage again that you take this opportunity po to clarify encountered issues related to the topic being discussed by our resource speaker. Okay, so we have 40% participated, 48. Ayan. So sana po mag-join na po lahat kasi this is our last day. So grab the chance na po na mag-participate tayo as well as kung may mga clarifications tayo in mind. Parang don't be shy to voice it out. Okay? So I'll be closing in 5, 4, 3, 2, and 1. Okay? So let us share the results. Okay. Most of the participants po answered letter B, 78%. May we invite our resource speaker, Judge Vitor, to give the correct answer. Is this the correct answer po, Judge?
Yeah, the 78% of those who answered the question got the correct answer. Yeah. 3019 is Anti-Graft and Corrupt Practices Act. The Government Procurement Reform Act is 9184, while the Anti-Red Tape Act is Republic Act 9485, but eventually amended by Republic Act number 110332, meaning which is otherwise known as Ease of Doing Business and Efficient Government Service Delivery. So yeah, 78% got the correct answer.
All right. Congratulations po for the 78% and thank you for the clarifications po, Judge. Let's resume na po with the session.
So next is civil liability. No. So as I said, criminal, then we are now civil. We're also civilly liable. So without prejudice, again, it says without prejudice to administrative sanctions that may be imposed in proper cases. Meaning without prejudice, meaning if there are other administrative sanctions aside from 9184, then that person is also liable. Okay. In conviction under this law and RA 3019. No? So what are the liabilities? Of course, restitution for the damage done. No? So we have to refund. No? We have to pay for the damage done because of the act violated under 1994. Then kung may mga benefit, especially dun sa corruption, no? Then forfeited in favor of the government of any unwarranted benefit derived from the act or acts in question or both at the discretion of the court. So forfeited kung anumang benefit na na-receive ng mga back members or ng private individuals because of that collusion, fraudulent act, then liable to pay or forfeited yung nabili mong bahay because of that, then forfeit yan in favor of the government. The third penalty is administrative. So I said before, in every criminal act a government official committed, there are other two sanctions, civil and administrative. So let's go now to administrative sanction. Okay. So in addition to the penal and civil sanctions, the hope subject to the authority delegated to the BAC, if any, shall impose on bidders or prospective bidders the administrative penalty of suspension for 1 year for first offense, for 2 years second offense, okay, and the succeeding offenses 2 years. No, so they are suspended from participating in the public bidding process and disqualified from further participating in the public bidding undertaken by the procuring entity. So this is suspension. So in suspension, the bidder or the prospective bidder is not allowed to participate in the public bidding of a certain being undertaken by the procuring entity. No? So it's only the procuring entity that impose suspension in which the bidder cannot participate. In other government agencies, in other procuring entities, the bidder suspended can still participate in other bidding, in other procuring entities. Okay. Then, forfeiture of bid security, if the acts were committed prior to the award or prior to the acceptance of the award, and the performance security if after the acceptance, but then there's certification of final acceptance 1 year after from the performance after the completion of the project, especially in infra project. So the procedures for blacklisting of manufacturers, suppliers, distributors, contractors, or consultants for government projects shall be undertaken in accordance with the guidelines to be issued by GPPB. No? Okay. Now, we will discuss actually blacklisting in our in one of the topic is the protest and blacklisting. So we'll discuss blacklisting, which is from part of administrative penalty. So let's go to termination of contracts. Okay. Okay. So subject to the guidelines on the termination of contracts under Annex I of the 2016 revised IRR of RA 91/84. So the objective determination of contract is promote fairness in the termination of procurement contracts and prescribe contract conditions and measures to enable the government to protect its interests. So in the termination of contract, it is always to protect the interest of the government. Okay. GPPB issued a resolution number 07/2019. And the subject matter is approving amendments to item 3, paragraph A, subparagraph 1, subparagraph A, B, and C of Annex I of 2016 revised implementing rules. Okay, it's the general conditions of the contract, Philippine bidding documents for the procurement of goods and clauses or clause on liquidated damages of the general conditions of the contract for procurement of goods, infra projects, and consulting services. It was approved on March 8, 2019, but effective on May 9, 2019. So there are 5 grounds for the termination of contract: termination for default, termination for convenience, termination for insolvency, termination for unlawful acts, and termination by contractor or consultant. So termination by default. The procuring entity shall terminate a contract when any of the following conditions attend its implementation. Okay. If aside the force majeure, meaning it is beyond, it is due to calamities, whatever, force majeure, no, beyond the control of the supplier. So this supplier, outside the force majeure, the supplier fails to perform or deliver any or all of the goods wherein such failure amounts to at least 10% of the contract price. Okay. As a result of force majeure, so this is for force majeure. Okay. The supplier is unable to deliver or perform any or all of the goods wherein such failure amounts to 10% of the contract. So it's the same, 10% of the contract. But in this, if it is due to force majeure, if failure to deliver within not less than 60 days, calendar days, from receipt of notice from the procuring entity that the force majeure is deemed to have ceased. Okay, nawala na po yung force majeure. So kailangang i-deliver ng supplier within within 60 days, within 60 calendar days. So for a period of not less than 60 calendar days after receipt of the notice from the procuring entity that the force majeure is deemed to have ceased. Or the supplier fails to perform any other obligation under the contract. So in this particular case, it is the procuring entity that shall terminate the contract. If outside the force majeure, failure to deliver at least 10% of the contract price. If force majeure, again, the same 10% for failure to deliver, no? For a period of not less than 60 calendar days after receipt of notice from the procuring entity that the force majeure is deemed to have ceased. So you have to deliver, the 10% should be delivered within 60 calendar days. After 60 calendar days, then that's a ground for termination for default. And the supplier fails to perform any other obligation under the contract. So the procuring entity shall terminate the contract. For infra projects, if it is due to the fault of the contractor while the project is ongoing, there is a negative slippage of at least 15%. So if there's a negative slippage of 15%, then the procuring entity can issue termination for default. If after the expiration of the contract time, the contractor incurred negative slippage of 10% or more due to its fault. No? So, nag-expire na yung contract, no? May negative slippage pa ang contractor ng at least 10%. Okay. In contracts for infrastructure projects, again, the contractor commits any or all of the following: abandon the contract works, refuses or fails to comply with a valid instruction of the procuring entity, or fails to proceed expeditiously and without delay despite a written notice by the procuring entity. Then there is a requirement, example, required minimum essential equipment in the project site, but upon inspection, wala doon, no? Hindi nagmi-meet ng minimum yung mga essential equipment. In accordance with the approved work plan and equipment deployment schedule. So that's another violation, no? So ito yung minimum equipment in accordance with the approved work plan and equipment. But during inspection, it was found out that kahit minimum di na-meet ng contractor. So that's also ground for the termination of default. The contractor commits any or all of the following: does not execute the works in accordance with a contract or neglects to carry out its contractual obligation. Okay. Neglects or refuses to remove materials or perform a new work that has been rejected as defective or unsuitable. Sa pan-inspection, sinasabi ng procuring entity, oh, ito, problema ito, dapat hindi ito pwede, hindi ito the construction is not in accordance with the approved program of works, approved design. No, dapat ito palitan. Kung hindi ito papalitan ng contractor, then the procuring entity has the right to terminate the project. Okay. Sublets any part of the work without approval of the procuring entity. No, especially pa subcontract. Okay, subcontract ikaw, then ako, I will not work this project anymore. So ikaw contractor, ikaw, you will be the one to perform or complete this project, diba? It's also a ground under criminal, civil, and administrative provisions, liability. So it's also a ground, diba? Subcontracting, especially if it is without the approval or of the procuring entity. So that's also a ground for default, termination for default. So aside from those liabilities mentioned before, the project will be terminated. For consulting services outside force majeure, the consultant fails to deliver or perform the outputs and deliverables within the period specified in the contract or within any granted extension. Or if it is a result of force majeure, the contract is unable to deliver or perform a material portion of the outputs and deliverables for a period of not less than 60 calendar days. So dapat within 60 calendar days, just like in goods, dapat within 60 calendar days, yes, to the consultant should deliver or perform the outputs and deliverables. After that, if it is more than 60 calendar days, wala pa rin, then that's the time that the procuring entity can issue termination for default. Or the consultant fails to perform any other obligation under the contract. So dapat malaman natin kung ano yung nasa kontrata, then kung may hindi na perform ng consultant, that's a ground for termination. Ito, the procuring entity, ito ay termination for convenience, may terminate the contract at any time for its convenience. The hope shall determine the existence of conditions that would make the project implementation economically, financially, or technically impractical or unnecessary. So pagtingin ng project, wala na, impractical na ito na project, doon na implement na, that's termination by convenience. Of course, the contractor will be paid quantum merit, no? Based on the expenses, based on the financial, the expenses that you have incurred, no, under quantum merit. So economically, financially, or technically impractical or unnecessary. Okay. Unnecessary in the sense that there are laws. Example, there are laws that would that changes the project. No? This is beyond the control of the procuring entity. Pursuant to the national laws, rules, and regulations. So that's the time that the procuring entity can terminate for convenience. Insolvency, no, The procuring entity shall terminate the contract if the supplier, contractor, or consultant is declared bankrupt or insolvent as determined with finality by the court of competent jurisdiction. Okay. Now, it is necessary to have a final declaration, final judgment of the court, no, that the supplier contractor is already insolvent. No, so we know also insolvency when the liabilities is more than the asset. No, so insolvent. Then the bankruptcy or insolvency of the supplier must be that as determined in the court of competent jurisdiction, because the insolvency cannot just be declared alone by the supplier cannot, or contractor consultant cannot say that, oh, we're already bankrupt based on our records, we're already bankrupt, we have more liabilities than assets. There must be a judicial decision, there must be a court decision that that particular entity is already insolvent, so that those remaining assets of the bidder will be divided in accordance with the rule or the law on which entity should be paid first out of that remaining assets of the uh, bidder. So if there's finality of judgment, then finality of judgment of insolvency, then the procuring entity shall terminate the insolvent. How can the contractor perform its obligation when it's already insolvent? The termination will be without compensation, provided that such termination will not prejudice or affect any right or action or remedy which has accrued or will accrue thereafter. Okay. Termination for unlawful acts. The procuring entity may terminate the contract in case it is determined prima facie that the supplier or contractor or consultant has engaged before or during the implementation of the contract in unlawful deeds and behaviors relative to the contract acquisition and implementation. So pag makita ng procuring entity na may mga unlawful acts or behaviors ang ginagawa ng contractor, okay, then at that particular instance that the procuring entity has the right to terminate the contract. Okay. So the termination for unlawful acts includes but not limited to the following. So these are the unlawful acts. Okay. Control, corrupt, fraudulent, collusive, and coercive practices. Diba? We have discussed that already before in our penal provision of the 9184, because there's corrupt, fraudulent, collusive, and coercive practices. No. So controlling shareholders in common with another bidder. Actually, if you have to look at the same grounds, the termination for unlawful acts, no, the grounds are the same with that of the administrative liabilities, penal, and criminal. No, the same pa lang. Controlling interest in common with another bidder. Okay. So, nagbibid yung isa, pero may controlling interest siya, more than 20% of the shares, at least 20% sa kanya, yung isa pala, company pa rin, na nagbibid is, mayroon pa rin siyang 20%. Okay. Then, bidder receive any direct or indirect subsidy from another bidder. No? So, nalaman na, pinafundingan pala ito ng itong bidder na ito, pinapandingan ng isang bidder of the same procuring entity. No? The same procuring entity, nagbibid silang dalawa, pero yung isang bidder, nagpa-fund, no? Nag-subsidize ng isang bidder who bidded also the bidder of the same procuring entity for the same project. Okay, bidders have the same legal representatives. Isa lang na tao ang kanilang authorized to represent the company. Okay. Bidder has a relationship with common third parties that we provide information or influence the bid of another bidder. Okay, ito. No. Siyempre, yung confidentiality, no. Then yung mga documents finords, no. Forged documents, yung mga nasa sinabit are forged documents. Okay. Termination by contractor or consultant. Okay. So, kung titingnan nyo, isa lang dito ang pwede, yung mismo ang contract, ang procuring entity ang mag-determine yung termination by convenience, no? If it is economically or financially impossible to continue with the project, ano? Because of causes due but not limited to, no, changes in the law, rules and regulations. Okay. In termination by contractor, in contracts for infrastructure projects, the contractor may terminate his contract with a procuring entity if the works are completely stopped for a continuous period of at least 60 calendar days, though no fault of the contractor. Okay. It's beyond the control of the contractor. So, stop for continuous period of at least 60 calendar days. Failure of the procuring entity to deliver goods, supplies, okay, materials, or right-of-way, especially sa right-of-way. No? The contractor cannot complete the project, cannot complete the construction of roads because of right-of-way problem. Okay. Another items under the terms of the contract or work is disrupted by adverse peace and order situation certified by AFP Provincial Commander and approved by the Secretary of National Defense. No? So, siyempre, kung naghihira na doon sa area, okay, more than 60 calendar days na, so pwede na ang contractor mag-terminate sa contract. No? It's more than 60 days. Pero kailangan continuous, no? Continuous na walang trabaho for at least 60 calendar days. So, kung interrupted yon on the third day may trabaho, hindi, that's not a ground for termination by the contractor or consultant. For consulting services, the consultant may terminate its agreement with a procuring entity if the latter is in material breach of its contractual obligation and has not remedied the same within 60 calendar days from receipt of the consultant's notice specifying such breach. So, ang breach dito, yung procuring entity. No? Siya yung nagbe-breach ng kontrata. So, then, the consultant can terminate the contract.
And now we are down to our second knowledge check. We will request our technical team to flash the second question. And the question is, the procuring entity cannot terminate the contract at any time for its convenience. Is it A, true, or B, false? Ayan. So, we will request again our participants po to select your answer in the Zoom poll being flashed on your screen. And for our Facebook Live viewers po, you may still join in this knowledge check session by dropping your answer in our comment section. Okay? So, we have 42% participated in our Zoom poll. 54, 57. So, let's wait for another seconds. And I'll be closing po in 5, 4, 3, 2, 1. Okay, let us share the results. Alright, so medyo dikit ng konti, pero mas lamang po ang letter B, false, with a 58%. Is this the correct answer po, Judge Vitor?
Yeah, the 58% got the correct answer. So I hope the 42% would know that, should know that the procuring entity can terminate the contract by convenience, no? So as we have lecture presented before, if it is necessary, it is impractical anymore or unnecessary to continue with the project, but the condition is it is because of or due to fortuitous events or some changes in the national law policies. So that's the only ground to change, no? example, it is not due to typhoon or earthquake. It is not necessary. It is not. It is impractical anymore to build or to continue building in that particular area when it is, kumbaga, it is not anymore. The foundation is not anymore. Or cannot sufficiently hold the project, the building, no? Kumbaga may problema na sa ilalim. So that would, in that particular case, the procuring entity can terminate the project with convenience. So of course, the bidder will be compensated accordingly. Thank you.
All right. Thank you po for the clarifications, Judge. So congratulations for the 58% who got the correct answer, and for the 42%, bawi po tayo next time. So I think we can now resume to the lecture proper.
The third penalty is administrative. So I said before, in every criminal act a government official committed, there are other two sanctions: civil and administrative. So let's go now to administrative sanction. Okay. So in addition to the penal and civil sanctions, the hope subject to the authority delegated to the BAC, if any, shall impose on bidders or prospective bidders the administrative penalty of suspension for 1 year for first offense, for 2 years second offense, okay, and the succeeding offenses 2 years. No, so they are suspended from participating in the public bidding process and disqualified from further participating in the public bidding undertaken by the procuring entity. So this is suspension. So in suspension, the bidder or the prospective bidder is not allowed to participate in the public bidding of a certain being undertaken by the procuring entity. No? So it's only the procuring entity that impose suspension in which the bidder cannot participate. In other government agencies, in other procuring entities, the bidder suspended can still participate in other bidding, in other procuring entities. Okay. Then, forfeiture of bid security, if the acts were committed prior to the award or prior to the acceptance of the award, and the performance security if after the acceptance, but then there's certification of final acceptance 1 year after from the performance after the completion of the project, especially in infra project. So the procedures for blacklisting of manufacturers, suppliers, distributors, contractors, or consultants for government projects shall be undertaken in accordance with the guidelines to be issued by GPPB. No? Okay. Now, we will discuss actually blacklisting in our in one of the topic is the protest and blacklisting. So we'll discuss blacklisting, which is part of administrative penalty. So let's go to termination of contracts. Okay. Okay. So subject to the guidelines on the termination of contracts under Annex I of the 2016 revised IRR of RA 91/84. So the objective determination of contract is promote fairness in the termination of procurement contracts and prescribe contract conditions and measures to enable the government to protect its interests. So in the termination of contract, it is always to protect the interest of the government. Okay. GPPB issued a resolution number 07, 2019. And the subject matter is approving amendments to item 3, paragraph A, subparagraph 1, subparagraph A, B, and C of Annex I of 2016 revised implementing rules. Okay. It's the general conditions of the contract, Philippine bidding documents for the procurement of goods and clauses or clause on liquidated damages of the general conditions of the contract for procurement of goods, infra projects, and consulting services. It was approved on March 8, 2019, but effective on May 9, 2019. So there are 5 grounds for the termination of contract: termination for default, termination for convenience, termination for insolvency, termination for unlawful acts, and termination by contractor or consultant. So termination by default. The procuring entity shall terminate a contract when any of the following conditions attend its implementation. Okay. If aside the force majeure, meaning it is beyond, it is due to calamities, whatever, force majeure, beyond the control of the supplier. So this supplier, outside the force majeure, the supplier fails to perform or deliver any or all of the goods wherein such failure amounts to at least 10% of the contract price. Okay. As a result of force majeure, so this is for force majeure. Okay. The supplier is unable to deliver or perform any or all of the goods wherein such failure amounts to 10% of the contract. So it's the same, 10% of the contract. But in this, if it is due to force majeure, if failure to deliver within not less than 60 days, calendar days, from receipt of notice from the procuring entity that the force majeure is deemed to have ceased. Okay, nawala na po yung force majeure. So kailangang i-deliver ng supplier within 60 days, within 60 calendar days. So for a period of not less than 60 calendar days after receipt of the notice from the procuring entity that the force majeure is deemed to have ceased, or the supplier fails to perform any other obligation under the contract. So in this particular case, it is the procuring entity that shall terminate the contract. If outside the force majeure, failure to deliver at least 10% of the contract price. If force majeure, again, the same 10% for failure to deliver. For a period of not less than 60 calendar days after receipt of notice from the procuring entity that the force majeure is deemed to have ceased. So you have to deliver, the 10% should be delivered within 60 calendar days. After 60 calendar days, then that's a ground for termination for default. And the supplier fails to perform any other obligation under the contract. So the procuring entity shall terminate the contract. For infra projects, if it is due to the fault of the contractor while the project is ongoing, there is a negative slippage of at least 15%. So if there's a negative slippage of 15%, then the procuring entity can issue termination for default. If after the expiration of the contract time, the contractor incurred negative slippage of 10% or more due to its fault. So nag-expire na yung contract, may negative slippage pa ang contractor ng at least 10%. Okay. In contracts for infrastructure projects, again, the contractor commits any or all of the following: abandon the contract works, refuses or fails to comply with a valid instruction of the procuring entity, or fails to proceed expeditiously and without delay despite a written notice by the procuring entity. Then there is a requirement, example, required minimum essential equipment in the project site, but upon inspection, wala doon, no? Hindi nagmi-meet ng minimum yung mga essential equipment. In accordance with approved work plan and equipment deployment schedule. So that's another violation, no? So ito yung minimum equipment in accordance with approved work plan and equipment. But during inspection, it was found out that kahit minimum di na-meet ng contractor. So that's also ground for the termination of default. The contractor commits any or all of the following: does not execute the works in accordance with a contract or neglects to carry out its contractual obligation. Okay. Neglects or refuses to remove materials or perform a new work that has been rejected as defective or unsuitable. Sa pan-inspection, sinasabi ng procuring entity, oh, ito, problema ito, dapat dito pwede, hindi ito the construction is not in accordance with the approved program of works, approved design. No, dapat ito palitan. And kung hindi ito papalitan ng contractor, then the procuring entity has the right to terminate the project. Okay. Sublets any part of the work without approval of the procuring entity. No, especially pa subcontract. Okay, subcontract ikaw, then ako, I will not work this project anymore. So ikaw contractor, ikaw, you will be the one to perform or complete this project, diba? It's also a ground under criminal, civil, and administrative provisions, liability. So it's also a ground, diba? Subcontracting, especially if it is without the approval or of the procuring entity. So that's also a ground for default, termination for default. So aside from those liabilities mentioned before, the project will be terminated. For consulting services outside force majeure, the consultant fails to deliver or perform the outputs and deliverables within the period specified in the contract or within any granted extension. Or if it is a result of force majeure, the contract is unable to deliver or perform a material portion of the outputs and deliverables for a period of not less than 60 calendar days. So dapat within 60 calendar days, just like in goods, dapat within 60 calendar days, yes, to the consultant should deliver or perform the outputs and deliverables. After that, if it is more than 60 calendar days, wala pa rin, then that's the time that the procuring entity can issue termination for default. Or the consultant fails to perform any other obligation under the contract. So dapat malaman natin kung ano yung nasa kontrata, then kung may hindi na perform ng consultant, that's a ground for termination. Ito, the procuring entity, ito ay termination for convenience, may terminate the contract at any time for its convenience. The hope shall determine the existence of conditions that would make the project implementation economically, financially, or technically impractical or unnecessary. So pagtingin ng project, wala na, impractical na ito na project, doon na implement na, that's termination by convenience. Of course, the contractor will be paid quantum merit, no? Based on the expenses, based on the financial the expenses that you have incurred under quantum merit. So economically, financially, or technically impractical or unnecessary. Unnecessary in the sense that there are laws. Example, there are laws that would that changes the project. No? This is beyond the control of the procuring entity. Pursuant to the national laws, rules, or regulations. So that's the time that the procuring entity can terminate for convenience. Insolvency. No. The procuring entity shall terminate the contract if the supplier, contractor, or consultant is declared bankrupt or insolvent as determined with finality by the court of competent jurisdiction. Okay. Now, it is necessary to have a final declaration, final judgment of the court, that the supplier, contractor is already insolvent. No? So we know also insolvency when the liabilities is more than the asset. No? So insolvent. Then the bankruptcy or insolvency of the supplier must be that as determined in the court of competent jurisdiction, because the insolvency cannot just be declared alone by the supplier cannot, or contractor, consultant cannot say that, oh, we're already bankrupt based on our records. We're already bankrupt. We have more liabilities than assets. There must be a judicial decision. There must be a court decision that that particular entity is already insolvent, so that those remaining assets of the bidder will be divided in accordance with the rule or the law on which entity should be paid first out of that remaining assets of the bidder. So if there's finality of judgment, then finality of judgment of insolvency, then the procuring entity shall terminate the insolvent. Because how can the contractor perform its obligation when it's already insolvent? The termination will be without compensation, provided that such termination will not prejudice or affect any right or action or remedy which has accrued or will accrue thereafter. Okay. Termination for unlawful acts. The procuring entity may terminate the contract in case it is determined prima facie that the supplier or contractor or consultant has engaged before or during the implementation of the contract in unlawful deeds and behaviors relative to the contract acquisition and implementation. So pag makita ng procuring entity na may mga unlawful acts or behaviors ang ginagawa ng contractor, okay, then at that particular instance, that the procuring entity has the right to terminate the contract. Okay. So the termination for unlawful acts includes but not limited to the following. So these are the unlawful acts. Okay. Control, corrupt, fraudulent, collusive, and coercive practices. Diba? We have discussed that already before in our penal provision of the 9184, because there's corrupt, fraudulent, collusive, and coercive practices. No, so controlling shareholders in common with another bidder. Actually, if you have to look at the same grounds, the termination for unlawful acts, no, the grounds are the same with that of the administrative liabilities, penal, and criminal. No, the same pa lang. Controlling interest in common with another bidder. Okay. So, nagbibid yung isa, pero may controlling interest siya, more than 20% of the shares, at least 20% sa kanya, yung isa pala company pa rin na nagbibid is mayroon pa rin siyang 20%. Okay. Then, bidder receive any direct or indirect subsidy from another bidder. No? So nalaman na, pinafundingan pala ito ng itong bidder na ito, pinafundingan ng isang bidder of the same procuring entity. No? The same procuring entity, nagbibid silang dalawa, pero yung isang bidder, nagpa-fund, no? Nag-subsidize ng isang bidder who bidded also the bidder of the same procuring entity for the same project. Okay, bidders have the same legal representatives. Isa lang na tao ang kanilang authorized to represent the company. Okay. Bidder has a relationship with common third parties that may provide information or influence the bid of another bidder. Okay. Ito. Siyempre, yung confidentiality, no? Then yung mga documents finords, no? Forged documents, yung mga nasa sinabit are forged documents. Okay. Termination by contractor or consultant. Okay. So, kung titingnan nyo, isa lang dito ang pwede, yung mismo ang contract, ang procuring entity ang mag-determine yung termination by convenience, no? If it is economically or financially impossible to continue with the project, ano, because of causes due but not limited to, no, changes in the law, rules and regulations. Okay. In termination by contractor, in contracts for infrastructure projects, the contractor may terminate his contract with a procuring entity if the works are completely stopped for a continuous period of at least 60 calendar days, though no fault of the contractor. Okay. It's beyond the control of the contractor. So, stop for continuous period of at least 60 calendar days. Failure of the procuring entity to deliver goods, supplies, okay, materials, or right-of-way, especially sa right-of-way. No? The contractor cannot complete the project, cannot complete the construction of roads because of right-of-way problem. Okay. Another items under the terms of the contract or work is disrupted by adverse peace and order situation certified by AFP Provincial Commander and approved by the Secretary of National Defense. No? So, siyempre, kung naghihira na doon sa area, okay, more than 60 calendar days na, so pwede na ang contractor mag-terminate sa contract. No? It's more than 60 days. Pero kailangan continuous, no? Continuous na walang trabaho for at least 60 calendar days. So, kung interrupted yon on the third day may trabaho, hindi, that's not a ground for termination by the contractor or consultant. For consulting services, the consultant may terminate its agreement with a procuring entity if the latter is in material breach of its contractual obligation and has not remedied the same within 60 calendar days from receipt of the consultant's notice specifying such breach. So, ang breach dito, yung procuring entity. No? Siya yung nagbe-breach ng kontrata. So, then, the consultant can terminate the contract.
And now we are down to our third and last knowledge check for this session. All right, so I think we can now flash the last question for this topic. Okay, the question is, in this procedure for termination of contracts, as a verified position paper shall be submitted by the supplier or contractor or consultant to the HOPE within 7 calendar days from receipt of the notice of termination. Is it A, verification, B, notice to terminate, C, showcase, D, recession of the notice of termination, or letter E, decision? Okay, you may now choose your answer in the Zoom poll flash on your screen. Okay, we have 8% participated na po in our Zoom poll. Let's wait for others to choose among the options flash on your screen. Okay. So I think we have 50% participated na po. And for those who have still questions in your mind po, feel free to drop your questions po. Since after this, we will be proceeding na po with our open forum. Hopefully, yung mga questions sumasama po sa ating open forum session. Okay? So we have 58% participated. Baka yung iba nag-CR break na, no? Okay, 62%. And we will be closing the poll in 5, 4, 3, 2, and 1. Okay, let us share the results of the poll. Okay, as of now po, Judge, we have 45% leading with letter A, verification, followed by letter B, notice to terminate, and third is 14%, letter E, decision, and fourth is rescission of the notice of termination, and last, letter C, showcase. What's the correct answer po ba?
Okay. Well, sad to note that only 5% got it. The correct answer is the show cause, because it's the show cause that will be submitted, no? Because in that particular show cause or in that particular show cause, they have to justify, the contractor should justify why they cannot, the contract cannot be terminated, no? So the answer is show cause.
Opo. Ayan, medyo nalito nga po yung ating mga
Mhm.
participants. By the way, congratulations po to those 5% who got the correct answer po for this knowledge check question. And that ends our discussion proper for the first half of our learning session. Again, thank you, Judge Vitor, for a very comprehensive discussion po on penal and civil administrative provisions. At this juncture, we will be having the most awaited open
What are the
forum,
procedures
but
for
please
the
be reminded po that questions which are initially gathered and filtered from the Zoom chat box and from our Facebook and YouTube live streaming comment section, as your research speaker shall only be answering questions related to our learning session. Once again, let's have our research speaker po to join in our open forum. Oh, I think we have still more ano po pala, lecture. So,
No.
opo. Okay. For the first question po, all right. So let us have our first question po. Okay. So I think we still have another lecture po pala. Sorry. So let's proceed na po with our lecture proper.
So what are the procedures for the termination of contract? Okay. Of course, as part of due process, as part of the of due process, it must be verified. No? Then notice to terminate. There must be a ground, no? Verified ground to terminate. Then notify the contractor. Then the show cause why it should not terminate the contract. Okay. Yung rescission of notice of termination, rescission in a sense that if the procuring entity has a ground that there's no need to terminate the contract, then in that particular instance, the procuring entity can resign the notice of termination of contract. Then it should be decided that the contract will be terminated, or if it is shown that it must be terminated. So the verification, okay, the first procedure for the verification of termination of contracts, in the verification, the implementing unit shall, or the procuring entity, within 7 calendar days from the receipt of written reports of acts or costs, which may constitute grounds for termination, verify the existence of such grounds and shall execute a verified report with all the relevant evidence attached. No? So, di ba, may sinasabi na termination, yung mga grounds, there are 5 grounds for termination. So, dapat may mga report na ganyan, na ganito ang na-commit ng isang contractor in order to terminate the project, the contract. So in that particular instance, the implementing unit of the procuring entity shall execute a verified report if the report or the acts which violates the contract are existing. Okay. So notice to terminate. So hopes shall terminate the contract only by written notice to the contractor, stating there in the following. Okay. Because of that verified report, the grounds and statement of the acts that constitute the grounds for which the contract is being terminated, the extent of termination, an instruction to the supplier, contractor, consultant to show cause why the contract should not be terminated. So that is a show cause order. With the other special instruction from the procuring entity, if any. So naka-attach na doon, nakasaad na doon yung grounds, no, as stated in the verified report. No, stated notice to terminate. So the procuring entity may issue a notice to terminate or withdraw, resign the notice to terminate at any time before the receipt of suppliers, contractors, consultants position paper. Because di ba may show cause order. Of course, the contractor would give its answer to the show cause order. But prior to the receipt of the supplier or bidder's position paper, the procuring entity has the right to withdraw the notice to terminate. No. Withdrawal of notice to terminate shall be based on procuring entity's determination that items or work subject of notice has been completed, delivered, or performed. So sa tingin ng procuring entity, nagkamali pala ang procuring entity dahil kompleto pala, na-delivered na, at saka na-perform na ang trabaho ng isang contractor. So there's no need to issue a notice to terminate. So there's no need to terminate the contract. So sa show cause, di ba may show cause doon why it should not be terminated. So from the receipt of the notice of the termination, so within 7 calendar days, the bidder or the supplier, the contractor, consultant shall submit a verified position paper. Okay. So we know already what is verification, no? That it should be that this position paper is prepared by me, that I am the respondent of the particular case, something like that. That I caused the preparation the same, that based on authentic documents and or personal knowledge. Okay. Failure by the supplier contractor to submit the verified position paper within the reglementary period shall cause the hope to issue the order of termination. Okay. So kailangan within 7 calendar days mag-submit ng verified position paper. Failure to do so, then the hope will issue now the order of termination. So not after notice of termination, it's now the order of termination. Then the decision. Within a non-extendable period of 10 calendar days upon the receipt of the verified position paper, the hope shall decide whether or not to terminate the contract. So remember, non-extendable period of 10 calendar days. from receipt of the verified position paper, the Hope shall decide whether or not to terminate the contract. Okay. Failure by the supplier, contractor, consultant to submit the verified position paper within the reglementary period shall cause the Hope to issue. No? Ito yung repeat na, no, di ba? Okay. So the termination shall be based only on the grounds stated in the notice to proceed. Of course, as part of due process. Kung yung ground to terminate is wala na mention in the notice to terminate, then that is a violation of due process law. The right of the respondent to due process to know the accusation against him or her. So, kung nakita, that would be a violation of due process if the contractor or the bidder, the contract is terminated on the ground not based on the notice to terminate. Because the notice to terminate, di ba, may grounds din doon why the contract should be terminated. So, yun po ang inatake ng contractor in his position paper. Kung ang termination in based not on the grounds stated in notice to proceed, then in that particular instance, the bidder was not able to defend himself. Okay, because the grounds are not stated in the notice to proceed, notice to terminate. So the Hope may create a contract termination review committee to assist him in the discharge of his function, especially in the decision. All findings or decisions of the CTRC are subject to the approval of the Hope, of course, because it is the Hope that will the last say, okay, in the termination of contract. Okay. So ito, di ba, sa alternative method of procurement, meron tayong takeover of contracts. So takeover of contracts in that part, especially under negotiated procurement. So if the procuring entity terminates a contract due to default or insolvency or for a cause, it may enter into negotiated procurement pursuant to Section 53C of 9184 and 53.3 of its IRR. So ang gagawin ng procuring entity, pupunta siya doon sa second, kung sa goods or infra, the second lowest calculated responsive bidder, and to the for consultancy highest rated responsive bidder, yung second highest, no, for negotiation. No. Invite, if not invite at least 3, no. So to continue the project. Sana yung 53.3.1 at 53.3.3, ito yung negotiated procurement, to takeover contracts. The contract may be negotiated starting with the second lowest calculated or highest rated bidder for the project and consideration at the bidder's original bid price. No? So yung original bid price ng bidder, yung nanalo, yung tinake over, okay, yun ang basis in the negotiation. Okay. If negotiation fails, then the negotiation shall be done with the third lowest, no? So kung wala sa second, yung next na. Kung wala talaga, naubos na yung all of the bidders in that particular project, no? Failure yung negotiation, then as mag-shortlist yung procuring entity, at least 3 eligible contractors shall be invited to submit their bids. A negotiation shall be made starting with the lowest calculated in the case of goods and infra and highest rated bidder in the case of consultancy. Okay. So authority to negotiate contracts for projects under these exceptional cases shall be subject to prior approval of the Hope within the respective limits of approving authority. Dahil iba, may limit sila sa authority. Ito lang, hanggang dito lang na amount yung pwede mong ma-approve. Okay. Okay. So ito yung sa termination for convenience, no? Yung procuring entity mismo ang nagdetermine. But this only applies to contract for goods, no? Goods shall be accepted or performed or are ready for delivery within calendar days after receipt of supplier's notice to terminate at the contract terms and prices. So ito, 'di ba, may failure to deliver within 60 calendar days, no? Okay. Nag-issue na ng notice to terminate. If within 30 days after receipt of notice to terminate, naka-deliver ang contractor yung sa goods 30 calendar days, then the procuring entity shall accept that items, no? Those items. So goods not yet performed or ready for delivery, the procuring entity may elect to have any portion delivered or performed and paid at the contract terms and prices, and or to cancel the remaining and pay to the supplier an agreed amount for partially completed or performed goods for the material and parts previously procured by the supplier. Okay. So written notice must be served to the procuring entity at least 30 calendar days before its termination. So ito yung kung ang contractor mismo, ang consultant mag-terminate ng kontrata, no? Yung no work within for a period of continuous no work for a period of 60 days or may mga place and order problem. So it must be served to the P at least 30 calendar days before its intended termination. The contract is then terminated if it is not resumed in 30 calendar days after receipt of such notice by the procuring entity.
Again, we will be having another knowledge check for this learning session. Okay? Can we flash po the questions for this knowledge check? Oh, but I think, sir, we've already done with the 3 knowledge check po for this first learning session. As I've said nga po, and finally, yun na po yung end ng discussion proper for the first half of our learning session. Again, thank you po, Judge Vitor, for a very comprehensive discussion. So at this juncture, we will be having the most awaited open forum, and I've said a while ago, please be reminded that questions which are initially gathered from the Zoom chat box and are filtered from our Facebook and YouTube live streaming comment section as your resource speaker shall only be answering questions related to our learning session. So I think we're ready na po with our questions. Can you flash the first question? Okay. First question po, Judge, is how can we improve collusion between government official and bidder? What is the remedy of the bank? I think you're still on mute po. I'll let you unmute, sir.
Okay. Okay. So clear? Okay na po.
Yes, sir.
How can we prove collusion? Yan ang problema. No, how can we prove collusion? Because unless, in collusion, unless one of the participants in the collusion will testify, then that's the way that we can file a case against those persons involved. Because in collusion, everybody, especially in example buyout or agreeing that this person will that only one person will submit the lowest bid, lowest calculated bid, with agreement that all other bidders shall increase their bid. Now, what what is actually happening is that this bidder who wanted to win will of course give consideration to those other to those other bidders who are willing to lose. No? So that's the problem on how to file a case against them because of collusion. There's only one way. If one of the colluder would testify, then that's the only thing that we can file a case against them. That's the only way. If one of the colluders will testify. But if none, no third party can do it. No third party can do it.
Thank you, Judge, for the clarifications. Let's proceed na po with the second question. The question is, what particular violation of the law could be applied if the LGU doesn't sell bid document to a bidder or contractor due to instruction of the hope?
Okay. Now, well, we know already the criminal liability, there's collusion, coercive practice, fraudulent, and corrupt practices. That's part of the corrupt practices. No, because probably in this particular case, the hope, or in their part, in this case, the mayor's example, has already a preferred contractor or bidder. No. So ang mangyayari kasi, pag yung preferred contractor or bidder has already purchased bidding documents, no, the secretariat, no, may you know, in one case we have we conducted an investigation when I was with the ILG, when there was instruction that the secretariat, the back secretariat, no, mag-absent na pag nabili na yung nakabili na yung preferred bidder, yung mga back secretariat di mo na makita sa opisina. Di mo na makita. Dahil palagi na pong wala. Well, in that particular case, how can the other bidders purchase the bidocs? Well, even though under the law or under the guidelines of the GPPB, the bidders can download the form from the GPP PhilJeps, di ba? Pwede nila i-download ang form at saka but their bidocs will not be accepted unless they will pay the cost of this documents. Now, so there's a violation, no? It's a corrupt practices. It is a corrupt practice that the public officer, the mayor, because it's a hope, can be accused, no? A case can be filed against the mayor, this particular case, for criminal liability. In this particular case, the hope may be liable also for Anti-Graft and Corrupt Practices Act, no, for giving undue influence, no. So aside from 9184, the mayor is liable also for Anti-Graft and Corrupt Practices Act. If it can also be proven that the mayor, because we're talking the hope, di ba? We're talking the hope, it's also the mayor because the participants are from the municipality, the different municipalities, the mayor. So in this particular case, the mayor, if it can also be proven that the mayor received financial consideration or any kind of consideration, baka sa itong bidding na ito, mayor, basta bigay mo sa akin yung contract na ito, may isa kang yung high-end latest Fortuner. Okay. So that's part of bribery. So again, the mayor will be liable, maybe liable also for bribery under the revised penal code. So tatlo, 9184 for violation of for Corrupt Practices Act, na Republic Act 3019 Anti-Graft and Corrupt Practices Act Practices Act for giving undue preference, undue advantage to one of the bidder, then the third is bribery. No?
All right, that is duly noted po, Judge Vitor. And for the third, and I think this is the last question on deck po. Is it allowed for an elected official or his or her family member to participate in procurement activities of the LGU where he or she is serving?
Okay. Actually, di ba may ano yan I think it's only up to third level of the back member. So kung doon yun, di ba may ano yun, affidavit, affidavit, omnibus sworn statement. Di ba sa omnibus sworn statement? It's under, di ba third ano lang yun, third, related by third level, no? Affinity or by consanguinity. So kung not only serving, no, hindi serving, dahil lang nakasa doon if it's related to the hope, the back members, and so on and so forth. So he cannot participate in the bidding. Now, also, so kung wala siya doon, it's beyond the degree specified under the omnibus rule. Okay, kung family member siya pero nasa ano na, fourth or fifth degree, no, parang first cousin or pamangkin ng first cousin, so pwede na, no, can still participate. However, there's also a provision in the local government code about pecuniary interest, no. So in that particular case, tingnan natin sa local government code, meron doon I will sandali lang ha, local government code. Nandun kasi, pero siya lang. So kaya ang ginagawa ng iba, they have to divest, no? That's part of the, they have to divest, no? Their business interest. Pero kung andun sa local government code, sino lang ang may kapangyarihan doon? 'Di ba? Mga business permit, mayor. So kung relative ng mayor, bawal doon. Pero kung mga sanggunian bayan members, wala namang power yung sanggunian members to approve business permit, no? Siguro kung or grant yung mga budget, no, nasa mayor naman yan. So wala yan sa mga sanggunian bayan members. So they cannot, so in that particular case, if it is SB members, no, families, no, they cannot be prohibited from participating in the procurement activities of the local government unit. Especially sa BAC, di ba, sa the sanggunian bayan members cannot be a member of the BAC dahil hindi sila kasali sa executive, no. They can be a end user, you know. So kung end user yung at that particular instance, example, may procurement activities tapos ang end user, ang that activity is for, or the goods to be procured is for the sanggunian bayan office, and one of the bidder is a member or a wife or the son of the sanggunian members, then that is a violation. That is a violation, no. So kaya yung iba kasi well, siguro usually dito yung ano especially yung sa mga gasoline station, di ba? Sa isang lungsod, sa isang bayan, ang may-ari ng gasoline station yung mayor. Yung iba nga, yung may mga ano pa, may nalaman ako na yung gasoline procure in that particular gasoline station owned by the mayor or owned by the family of the mayor, pero yung resibong ginagamit hindi galing diyan na gasoline station, ibang gasoline station ang ginagamit. I mean, ibang gasoline station, resibo ng ibang gasoline station ang ginamit, pero yung gasoline or yung fuel doon kinuha sa gasoline station owned by the mayor. No. In that particular case, we cannot prove that because ang ginagamit na resibo ang mayor. So again, kung family members may limitation, no? Kailangan hindi related within the third level, within the third degree by affinity or consanguinity to the BAC, to the HOPE, to the technical working group, and so on and so forth of the local government. Kung wala doon, then they can participate. Also, under the local government code, Usually kasi they have to divest their business interest to other persons. No, that is provided under the local. If they also violate that and also sa procurement, then they also, aside from violation under the local government code, pero local government code wala po doon walang criminal liability doon. So pwede pa rin sa 3019. So yan lang po.
Ayan. So hopefully malinaw na po sa ating mga participants regarding this scenario kung ano na po yung gagawin natin if ever maka-encounter po tayo in our LGUs. Okay? So that concludes our open forum for the, I think ito na po ba yung last pala? Sorry, ayan. So I think that concludes our open forum po for the first part of our session. But before we dive into the second part or lecture of our session, let us first watch a short audio-visual presentation on how you can request training in government procurement. You may also take a short bio break. Thank you very much and see you in a short while. Again, that was a short audio-visual presentation on how to request training in GPPB ESO. For a more quick guide in government procurement and other related short videos and audio-visual presentation, you may visit our official website at www.gppb.gov.ph. I hope everyone is back. Can I have a heart reacts from our participants if you're ready with our second part learning session? Okay. Ayan. So, ready na ang MLGUS Salcedo. Okay. Let's proceed na po with our learning session. Take it away po, Judge Vitor.
So let's go now to protest mechanism and blacklisting guidelines. Okay. Outline for topic: protest mechanism, requisites for filing a verified protest, valid protest, procedure and resolution of protest, then black.
Recording in
Disqualifying
progress.
its bid, and their documents should be admitted to something like that. So it says that at any procurement stage may be questioned by filing a request for reconsideration, because request for reconsideration is mandatory. No? So how it should be done? So within 3 calendar days from receipt of the written notice of or upon verbal notification with regards to the result or the decision of the BAC, then the bidder, especially the losing bidder, shall file a request for reconsideration within 3 calendar days from receipt, either written or in verbal notification. So what will happen is they have to do that within 3 calendar days. Just remember, it's calendar days. It includes Saturdays and Sundays or holidays. But of course, based on the rule, existing rule, the rules of court, that if the last day for filing is holiday, then the next working day should be the last day. So if the third day happens on Saturday, then and Monday it should be submitted on Monday, the first working day after the holidays, or no working day. Then so the BAC should decide the request for reconsideration within 7 calendar days. So that's why in the technical working group there should be a recommendation that there should also be legal team from the technical working group, that they would drop the request for reconsideration in case of protest. So some would say, sir, what's the difference between request for reconsideration or motion for reconsideration? Well, for me, it's the same. It's the same. You're asking for, because motion is a request also. So it's a request. So it's the same. So you want to reconsider, the BAC would reconsider the decision. So if the request for reconsideration is denied, then that's the time that we would file a protest before the head of the procuring entity. So in the case of the LGUs, it should be the mayor, the governor, or the punong barangay. So if request for reconsideration or motion for reconsideration is denied by the BAC, then the BAC, the bidder may file a protest in writing before the head of the procuring entity. May, because it is not mandatory. If the bidder is already satisfied with the decision of the BAC and is satisfied with how the BAC ruled in their request for reconsideration, then they will not file a protest anymore. But if they still contested, then they file to a protest. So the protest for reconsideration is mandatory. It's mandatory. If there is no request for reconsideration, protest cannot be done. And the protest can only be done also if the request for reconsideration has been resolved. So requisites for filing a protest must be in writing through a verified position paper. Now, verification that I, the complainant of this case, that has caused the preparation of this protest, that all the documents are in are came from original documents, that are from personal knowledge, no? And the payment of non-refundable protest fee to be paid in cash, and of course, a certificate against forum shopping. Well, the certificate against forum shopping, no, would say that you are not, the bidder is not filing the same action before other body or quasi or judicial or quasi-judicial body. So non-payment of non-refundable protest fee. So that's why there are people, there are bidders that would complain immediately to the mayor, Mayor, dapat ganito, ba't ganito, no? Ang back problema to. It should not be tolerated. It should, then the mayor would say, okay, back, anong nga naman, anong na may reklamo diri, no? It should not be tolerated because the back should, the bidder should file a request for reconsideration before the back, so that the back, if it is if it ruled the disqualification by mistake, they can correct, no? The back can correct the mistake. So that would give the back the opportunity to correct itself, no? And also to pay, and for the protestant or for the protestant to pay the protest fee, no? Before the hope would rule on the protest. Para, ano ba yung protest? Of course, for the honoraria of the back members, di ba? Okay. Then it should be addressed to the hope or the mayor, the governor, because it is these people who will decide, no, the protest. And it should be filed within 7 calendar days from receipt of the back resolution denying the request for reconsideration. So the position paper would state the bidder's name and office address, no? The name of the project or the contract, the implementing office or the procuring entity, brief statement of facts, issues to be resolved. No, of course, the issues to be resolved, why it is disqualified, something like that. Why the documents is denied. So other matters, information pertinent and relevant to the proper resolution of the protest. So then the last is the certification against forum shopping. Okay. So ito yung verification. The defiant or the complainant has read and understood the contents thereof and allegations therein are true and correct of his or personal knowledge or based on authentic documents. No? So if there is no verification, it is considered a mere scrap of paper. So outright dismissal of the protest. Unsigned, produce no legal effect and results to outright dismissal of the protest. So failure to comply shall not be curable by amendment of the verified position paper. So, di ba, within 3 days, you should file a request for reconsideration. No. So, if there's something kulang, no, they cannot amend, meaning they cannot file another verified position paper with amendment. They have to file a new verified position paper. So, bayad na naman sila ulit. Okay, dahil kung amendment, walang bayad. So, a new verified position paper. Ang problema nito, kung they file the protest nang sa deadline na. Example, the third day, doon pa sila nag-file. Problema pala, kung may time pa, then they can do that. They can submit a new verified position paper. Kung wala ng time, they cannot file that anymore. No? So on the second day ba or morning ng third day, nakasubmit sila ng position paper ng protest, pag tingin nila, uy, kulang, o may problema, or walang verification, or walang certificate of non-forum shopping, they can file a new verified position paper. But they cannot amend. Ang amendment kasi, nandun yung first nilang verified position paper, tapos may amendment. So parang carry over pa rin yun sa deadline ng first position paper. No. Pero kung sa ganito, walang carry over. Hindi yun na dahil nakasubmit ka sa first verified position paper on the last day, may amendment na, pwede pa yun dahil ang position paper nakasubmit on the third day, kung may amendment, mag-recon pa rin yun sa third day. Pero kung walang amendment, kung new verified position paper, hindi na siya pwede makasubmit dahil that is considered new. No? Okay. Resolution of protest. So reset of denied protest for reconsideration. Okay. Filing of protest within 7 calendar days from receipt of the party concerned of the resolution of the CBAC denying its request for reconsideration. Okay. Kung granted kasi yung request for reconsideration, of course, yung ino-object nila, mag-carry na yon, mag-grant na yon. Kung sinasabi na deny sila because of that, then kasama na sila sa qualified bidder. Okay. And the hope shall resolve the protest within 7 calendar days from receipt. Then the head of the BAC secretariat shall furnish the bidder with a copy of the decision within 7 calendar days from receipt. No. So the filing of protest should be in the verified position paper with certificate of non-forum shopping and payment of non-refundable protest fee. Okay. So to discourage naman protest. Okay. Any protest taken from any decision treated in 9184 and its IRR must not be stay or delay the bidding process. However, walang award unless ang protest ma-resolve. No. Unless ang protest ma-resolve, walang i-award. Court action may be resorted to only after the protest shall have been resolved with finality. Okay. So that is what we call the doctrine of exhaustion of administrative remedies. Kung walang protest, di ba? Mandatory yung request for reconsideration, then protest. Kung wala silang protest, then they cannot file an action for petition for annulment of the award before the regional trial court. Because protest is condition sine qua non. Kumbaga, kung walang protest, then it should be denied. No? Yung petition for annulment of the award will be denied, so shall be denied because walang exhaustion of administrative remedies. Okay, ito yung protest fee, no? So, kung ang ABC is 50 million pesos and below, ang protest fee is 0.75%. Kung more than 50 million to 100 million, 500,000, more than 100 million pesos to 500 million, 0.5% of the ABC. More than 500 million pesos to 1 billion pesos, 2.5 million. More than 1 billion pesos to 2 billion pesos, 0.25 of the ABC. More than 2 billion pesos to 5 billion pesos, 5 million pesos ang protest fee. Kung more than 5 billion pesos, it is 0.1% of the ABC. So yun.
And now we are back to our knowledge check session po. Okay, so may we ask our technical team to flash the question on screen? The question is, the non-payment of the protest fee does not toll the prescriptive period for filing a protest, and it becomes a justifiable basis for the hope not to entertain a protest. Is it A, true, or B, false. Okay? So parang 50-50 yung una ko nakita sa screen. We have 27% participated po. So while waiting for the others to answer or to select their answer po in our Zoom poll, may we remind our participants po to follow the required name format, that is your municipal local government unit name underscore your full name, para naman po baka mamaya prize question na and magipong valid yung answer natin kung tayo ang unang makapag-post ng correct answer. Okay? So we have 63% participated and we'll be closing the poll in 5, 4, 3, 2, and 1. Okay? Let us share the results po. Judge Vitor, most of the participants with 69% answered letter A, true. Is this the correct answer po?
Yeah, 69% of those who answered got the correct answer. No. Non-filing of the protest pay does not toll the prescriptive period in filing the protest. It's true.
Alright, so noted po. And yung ating 31%, bawi po ulit tayo sa next case. And let's continue na po with our lecture proper. Thank you.
Okay. Let's go down to uniform guidelines on blacklisting. Okay. So the guidelines on blacklisting is based on GPPB Resolution number 40-2017, approving the revised uniform guidelines for blacklisting of manufacturers, suppliers, distributors, contractors, and consultants. It was approved on December 21, 2017, but effective only on September 4 of 2018. Okay. Then, another GPPB Resolution number 14-2020, approving the prescribed form of blacklisting order, the implementation of the online blacklisting portal for posting and updating of status of blacklisted entities. It was approved on June 25, 2020 and effective on August 7, 2020. Okay. So blacklisting is part of administrative penalty disqualifying a person or
grade
from participating in any government procurement for a given person. So blacklisted person or entity, a person or entity who was disqualified by an agency or included in the GPPB consolidated blacklisting report. So, but before a certain entity or person is blacklisted, there is prior suspension. So it's an interim penalty. Okay. Suspension is the interim penalty imposed for infractions committed by a bidder during the procurement stage, whereby such bidder is prohibited from further participating in any of the bidding process of the agency. Shall be effective during the period of motion for reconsideration and or appeal and shall terminate only upon decision by the Hope or appellate authority. So ang suspension happen, for example, Municipality X, may bidding, sinuspend niya yung isang bidder because of infraction, yung company, example, bidder A, so the bidder A cannot participate in any further bidding in that municipality. But that bidder can still participate in the bidding of other agencies, no? Of other LGUs, pwede pa. No? Pero kung blacklisting na, wala na pong pwedeng mabidingan po niya. Dahil lahat ng government agencies, blacklisted po siya. Kahit isang municipality lang ang blacklist, blacklisted yung isang bidder sa lahat ng government agencies. Sa suspension, dun lang sa nagsuspend na hindi siya pwedeng makaparticipate sa bidding. Okay. For the appellate authorities, well, sa LGUs, sino bang appellate authority? There's no more appellate authority for the LGUs because mayor na lang, mayor. Okay. Pag ano na sa mayor, then they have to file an action. blacklisting decision of government agencies that are not subject to general or administrative supervision or control of any department or office or government unit shall be final and executory. Okay. So doon sa consolidated blacklisting report, no, nakasad naman doon kung how many years, 1 year or 2 years pang blacklisting. Pag na-meet na yung year, then automatic delisted as blacklisted ang person or entity. Okay. So apply sila sa, the blacklisting sila apply to the following persons. Individuals or sole proprietorship, bidders and spouses. Okay. Kung yung mga single proprietor or individual na bidder, si Mr. A, meron siyang business, no? Si spouse, husband. Yung wife naman, meron din, separate. No? So kung si spouse, husband, blacklisted din yung spouse, wife na entity. So yung mga partnership, kung ang isang partner, blacklisted, okay, kasama na yung partner po niya, no? Blacklisted din. So kung yung partner niya may iba ding negosyo na pwede makabid sa government, then blacklisted din yun. For cooperative, no, the cooperative itself and the members of the board of directors, general manager, or executive officer. For partnership or joint venture consortium, or has a blacklisted member and or partners, as well as a person or entity who is a member of blacklisted joint venture or consortium. So yung mga kasama doon sa partnership, joint venture, consortium, kung may mga negosyo din sila, blacklisted din. Then kung corporations, a single stockholder together with his or her relatives up to the third civil degree of consanguinity or affinity under an assignee holding at least 20% of the shares therein. No? So kung isang corporation, isang bidder, binacklist po ninyo, then 20, kung ang isang stockholder doon, yung may isa ding corporation nagbibid, no? Nagbibid po sa inyo. Pero that bidder owns one of the stockholder owns 20% of the blacklisted corporation, then that corporation na nagbibid na di pa na blacklist, kasama yun sa blacklisted. Dahil isa sa owner doon may control sa at least 25% sa blacklisted corporation.
All right, we're now again on our knowledge check po for this learning session. May we ask our technical team to flash the second questions to this topic? All right, the question is, blacklisting is an interim penalty imposed for infractions committed by a contractor during competitive bidding stage, whereby such contractor is prohibited from further participation in the bidding process of an agency. Is it A, true, or B, false? Okay, you may now choose po your answer in the Zoom poll feature flash in our screen. Okay, just a simple note lang po to our participants po pala, in order to maintain clarity and to be able to properly manage the time, may we respectfully request for our dear participants to keep your microphone be muted throughout the entire session. Okay, so we have 55% participated na po in our Zoom poll, 62%. And we'll be closing na po our Zoom poll in 5, 4, 3, 2, and 1. May mga last minute changes pa yata ng mind. Ayan, so let us share the results na po for this question. Doctor, for this one po, Judge Vitor, our answer po is letter A, true, by 71% of the participants. Is this the correct answer po?
Well, only 29% got the correct answer. No. So the answer
Parang
is
medyo
false.
tricky po ata yung question.
Ah.
Kaya medyo nalito po siguro sila.
So blacklist, it is suspension. No? Suspension is the interim penalty. So it says naman, di ba? Participating, no, prohibited from participating in the bidding process of an agency. That is only for suspension. Because blacklisting is you are prohibited, the bidder, the blacklisted bidder is prohibited from participating in the bidding process of all government agency. No?
All
So
right.
all government agency. So the answer is false. No.
Ayan. So, tandaan po natin na false po ang tamang sagot for this particular question. So, congratulations po again for the 29% who got the answer correct. So, let's resume na po with our lecture proper.
So there are two stages in blacklisting: during procurement stage and during implementation stage. So let's go first with the during procurement stage. Okay. Actually, pare-pareho lang, more like the same with the liabilities, no, sa administrative, penalty, civil, and criminal. More or less the same ground. No? So, diba? Containing false information or falsified documents, submission of bids that contains false information or falsified documents, or concealment of such information in bids in order to influence the outcome of eligibility screening and or any other stage of the public bidding. Then refusal to clarify or validate in writing its bids during the post-qualification with a period of 7 calendar days from receipt of request for clarification. Okay. Any documented, unsolicited attempt by a bidder to unduly influence the outcome of the bidding in his favor. Okay. Allowing the use of one's name or using the name of another for purpose of public bidding. Okay. Withdrawal of a bid or refusal to accept an award or enter into contract without justifiable cause after has been adjudged as having submitted the lowest calculated unresponsive bidder or highest rated responsive bidder in case of consultancy. Okay. Refusal or failure to post the required performance security within the prescribed period. Okay. All other acts that tend to defeat the purpose of the competitive bidding, such as habitually withdrawing from bidding or submitting late bids or patently insufficient bids for at least 3 times within a year, of course, without valid reasons. Okay. So these are the grounds for blacklisting during procurement stage. As I said, this is the same ground, or most of these grounds are the same grounds in penal committed, in which the private or public officer is criminally, civilly, and administratively liable. So what are the sanctions for blacklisting during procurement stage? Of course, the bid security. Diba? Nag-deposit sila ng bid security, ma-forfeit yung bid security nila. Then, first offense, blacklisting for 1 year. Second offense, blacklisting for 2 years. Or enforcement of bid securing declaration, di ba? Kung wala kang allow yung walang bid security, then yung enforce yung bid securing declaration. So, ang ano doon is blacklisted pa rin. No? So, without prejudice to the imposition of additional administrative sanctions, as the internal rules of the agency may provide and or criminal prosecution. So we have discussed that before. Okay. Ito, during procurement stage. So who will initiate? Any bidder or prospective bidder, any authorized observer, or the BAC itself can file a blacklisting action. No? So contractors shall refer to manufacturers, suppliers, distributors, contractors, and consultants. So the BAC notifies contractor in writing upon verification of existing grounds that a complaint has been filed, that is opportunity to show cause, the hearing, no? So may show cause order yan. These are the grounds for you will be show cause why you cannot be blacklisted because you committed the following grounds to offenses. So that the complaint has been filed, no? Ito yung kasama yung sa show cause order that has the opportunity to show cause that a hearing shall be conducted upon request, the consequences of being suspended and blacklisted. Because yung request for hearing, discretion yun sa respondent kung gusto pa niya magpa-hearing. Kung ayaw na niya, okay lang. No? The consequence of being suspended and blacklisted. So the contractor shall submit its written answer to BAC with documentary evidence and request for hearing, if so desires, within 5 calendar days from receipt of notification. So remember, it's 5 calendar days. No extension is allowed. Of course, dahil kasi, di ba, if allowed ang extension, madidelay yung bidding. Okay. If contractor does not submit an answer, because the contractor, after receiving the show cause order, pwede naman po, pwede naman din di siya mag-submit ang answer. Okay. So, with that, the BAC will, dahil walang answer, recommend to the HOPE the suspension of the contractor and the forfeiture of bid security. So, within 15 calendar days from receipt of the BAC resolution, records of the BAC proceeding, the HOPE determines whether there is a reasonable cause to blacklist the contractor. So, it's either to dismiss the case. Kung may reasonable cause, issue ng suspension, then forfeiture of bid security. Okay. So suspension order and bid, wala pang blacklisting dahil sa dapat yung suspension order becomes final and executory. That's the time that ma-issue na po yung blacklisting order. So kung mag-submit po siya and requested for hearing, so yun, request for hearing, yes, ang BAC magkakandak ng hearing. Kung hindi po siya nag-request for hearing, the BAC will determine the existence of fault based on the complaint, answer, and documentary evidence and facts verified. So kung walang hearing, doon yung BAC will just base their decision on the papers submitted to them, the complaint and the answer. No, yun lang. Kung ng hearing, the BAC will set the date and time for hearing. Then, of course, will decide the case based on complaint, answer, and the documentary evidence and facts verified. Okay. Then, submit to the HOPE. No? So again, the HOPE would dismiss or issue suspension order and forfeiture of bid security. Okay. Okay. So the HOPE shall furnish the suspended contractor a copy of the decision after its promulgation. So what's the effect? So suspended immediately upon receipt of the notice of the decision. Okay. The bidder, the suspended bidder, has the right to file a motion for reconsideration, and if denied, can appeal. No? and shall terminate only upon the reversal of the decision by the hope or appellate authority. So, if the motion for reconsideration or appeal is filed, the decision shall become final and executory after the lapse of 7 calendar days. And that's the time na nag-issue na po ang hope ng blacklisting order. Okay. Because the motion for reconsideration or appeal is a privilege. No? It's not a right, meaning it's up for the suspended bidder to file a motion for consideration or appeal. He cannot be forced to do so. It's up for him. It's up for the bidder. So kung wala siyang motion for consideration or appeal to the decision of the hope, suspending or blacklisting the bidder, mag-issue, suspend, then i-blacklist na po siya after 7 calendar days. Okay. So, file siya ng motion for reconsideration. Hope resolves the motion. So, file siya ng motion for reconsideration. That the decision, within calendar days from receipt of the decision, the basis of the motion for reconsideration is that the decision does not conform with the evidence or facts, or there is a newly discovered evidence. Okay. Then, or nagpa-file siya ng appeal, no? Kung walang appeal, within 7 calendar days, after 7 calendar days, ang hope mag-issue ng blacklisting order. Kung nag-file siya ng appeal, then the appellate authority shall resolve the appeal within 7 calendar days. So if appeal is not granted, hope issued blacklisting order. Okay. Filed with the appellate authority within 7 calendar days, yung appeal. So ang MR dapat 3 calendar days. Ang appeal is 7 calendar days. So ito, during contract implementation. Okay. So what are the grounds for blacklisting during contract implementation stage? Okay. Failure of the contractor due solely to his fault or negligence to mobilize and start work or performance within the specified period in the notice to proceed. Okay. Failure by the contractor to fully and faithfully comply with its contractual obligations without valid cause, or failure by the contractor to comply with the written lawful instruction of the procuring entity or its representative pursuant to the implementation of the contract. Ito, assignment and subcontracting of the contract or any part thereof or substitution of key personnel named in the proposal without prior written approval by the procuring entity. So assignment and subcontracting is bawal. No? Dahil kung may subcontractor po, dapat kasama yon sa kung i-allow yan ng procuring entity, dapat kasama yon sa bidding. Dahil the qualification of the contractor should be the same with the main contractor. Okay. Yung ginagawa natin ng mga subcontracting, actually, hindi yun natatawag natin. We can't call that subcontracting because, well, between the main contractor and that the subcontractor, it's subcontracting. But for the procuring entity, there is no subcontracting. So the liable is always the principal contractor. So kung nagkamali yung subcontractor, yung principal contractor pa rin ang liable. No? Dahil walang approval. No? Bawal yun. Ito yung substitution of key personnel named in the proposal, especially sa consultancy, di ba? Sa consultancy, the government will hire consultants based on expertise, based on experience or educational qualification. During the bidding, nakasad na 15 years experience in this particular field or has a doctorate degree, iyong pinalit na personnel a master's degree holder or not a doctor's degree holder or 10 years ang experience. Ang kailangan natin ang original is 15, yung nagpumalit 10, so that is not allowed without written approval. Ito, for procurement of goods, no? Unsatisfactory progress in the delivery of the goods by the manufacturer, supplier, distributor arising from his fault or negligence or inferior quality. no? Inferior, hindi naka-comply sa specification ng during sa bidding. May mga specs, so yun ang minimum dapat na i-meet ng bidder. So kung yung specifications, no, inferior yun sa, I mean, yung nabigay na mga goods is inferior to the or unsatisfactory to the specification specified in the bidding, then that would be the bidder is liable for or maybe blacklisted. Okay, consulting for services for performance by the consultant or services arising from his fault or negligence. Okay. For the procurement of infrastructure projects, poor performance by the contractor or unsatisfactory quality and or progress of work arising from his fault or negligence as is reflected in the CPs or the existing performance monitoring system of the procuring entity. Okay. So, willful or deliberate. So, kailangan willful or deliberate yung pag-abandon. No? Kung may grounds, no, may justifiable cause. Well, ito yon. Without justifiable or lawful cause. Abandonment or non-performance of the project or contract by the contractor resulting to substantial breach thereof without lawful or just cause. May gira doon. Dahil sa bagyo, naging inaccessible yung area. So that would be a ground. That would be a justifiable cause. So in case it is determined prima facie that the contractor who has engaged before or during the implementation of the contract in unlawful deeds and behaviors related to the contract acquisition and implementation as enumerated, pwede yan sa ground for the termination of the contract. Actions. Dahil during contract implementation, di ba, may award na, dapat ang ma-forfeit yung performance security. Forfeited yan. The same, blacklisted for 4 years for the first 1 year for the first offense, blacklisted for 2 years for the second and subsequent offenses. Again, without prejudice to imposition of additional administrative sanctions as the internal rules of the agency may provide, and or further criminal prosecution. Okay. So, blacklisting procedure during contract implementation. So, upon termination of contract due to default or unlawful acts of the contractor, the HOPE shall issue within 7 calendar days a blacklisting order. Okay. Where notice contract termination is no longer possible, okay, but the contractor committed acts or causes which may constitute grounds for blacklisting, the implementing unit shall, within 7 calendar days after the lapse of project duration, post the significant relevant evidence subject to the project. Of course, notice, show cause decision, notice to the blacklisting, no? Notice of blacklisting. Okay. So, tapos na po yung project. No? Based on the time. No? So, nilapse na po yung duration. So, dapat within 7 calendar days, no, dapat within 7 calendar days, dapat may verified report, no, that to be attached for the notice of blacklisting. No? Remember, 7 calendar days after the lapse of project duration. After 7 days, you have no more ground because under the law, pag yung 7 calendar days, that is mandatory. Okay. So yun. Okay. So the HOPE shall initiate the blacklisting procedure by written notice to the contractor. Okay. That is, of course, due process. Due process pa rin. Let the contractor contradict the allegations of the procuring entity. So a statement of the acts that constitutes the grounds for blacklisting. So ano yung grounds, di ba? We have already mentioned about grounds for blacklisting during contract implementation. So yun. instruction to the contractor to show cause as to why it should not be blacklisted, and instruction and special instruction to the procuring entity, if any. No. So the notice of blacklisting shall be accompanied by a copy of verified report. Verified meaning may verification pa rin, di ba? Just like the protest. So within 7 calendar days from receipt of notice of blacklisting, the contractor shall submit to the HOOP a verified position paper stating why it should not be blacklisted. That's just show cause. No? If the contractor fails to show cause after the lapse of 7 calendar days, either in action or by default, the HOOP shall issue a blacklisting order. So the second paragraph, kung after 7 calendar days, no, walang sinabit na action or show cause ang contractor, ang HOOP can issue immediately the blacklisting order. Okay. So the decision is based on the paragraph 1, the first ballot when the contractor submitted a verified position paper. No. So if the contractor submitted a verified position paper within 7 calendar days, then the HOOP shall within non-extendable period of 10 calendar days from receipt of the verified position paper, the HOOP shall decide whether or not to blacklist the contractor. It shall serve a written notice to the contractor of its decision, which shall become final executory after the lapse of 7 calendar days from the receipt of notice of the decision. Okay. So kailan maging final executory? Of course, kung walang MR, walang appeal. So example, if the bidder did not file a motion for consideration and decision to suspend, diba, suspension ng muna, decision becomes final executory after the lapse of 7 calendar days counted from the receipt of the notice of decision. Okay. Walang MR. Second, if the bidder did not file an appeal, no, may MR po siya, may motion for reconsideration, pero deny yung motion for reconsideration, dapat mag-appeal, pero hindi siya nag-appeal. Then, that decision becomes final executory after the lapse of 7 calendar days counted from the receipt of the resolution on the denial of their motion for reconsideration. Third, if an appeal was filed and the same was denied, the decision becomes final executory upon receipt of the agency and or person entity concerned on the decision of protest. Okay. Status of blacklisted person. Before issuance of blacklisting order, suspended pa lang. So the airing contractor may participate in the procurement of any government project except in the agency where is suspended. So that is suspension. Okay, blacklisting order issued before the notice of award. Of course, kung may shall not be, kung before the issuance of notice of award, then it shall not be awarded to the qualified bidder, but to the second, doon ka na sa second responsive, lowest calculated responsive bidder. Second, third, kung consultancy, the highest, second highest, something like that. Blacklisting order issued after the issuance of the notice of award. Okay. The award of or awarded project or contract shall not be prejudiced by the said order, provided that the said offense are connected with the awarded project or the contract. Okay. So kung ibang project yan, no, may notice of award na, that's the time after na issue, then after the issuance of notice of award, na issue yung blacklisting order. So yung awarded project, it cannot be affected, no, unless not connected, and hindi yan affected, no. Affected yan if connected with awarded project. Okay. This one is after the issuance of notice of award, but before the issuance of blacklisting order. So continue pa rin yung project niya po na may notice of award na po. Pero kung doon sa agency concern, even after the notice of award at saka yung yung may notice of award, the same project yon sa kanyang na-issue na blacklisting order, hindi na pwede yun. Okay. Even if may notice of award. So the effectivity period for the penalty shall be clearly stated in the blacklisting order and shall commence in the same date as of each issuance. Okay. Penalty. Remaining period, di ba sabi natin, first offense, 1 year blacklisting. Second and subsequent offense, 2 years. Second offense, 2 years. Third offense, 2 years. Fourth offense, 2 years. So, period of previous, so plus 2 years. Plus 2 years. Kung offenses na po, marami, third offense, second offense. So, ano yung remaining period niya? Then, plus 2 years. Okay. Example, nakaserve siya ng 1 year and a half. Second offense na po niya. First, so example, sa first offense, serve siya ng 1 year. Pero half year pa lang, may another blacklisting order. That's a second offense. So, plus yung new 2-year blacklisting order, start from 6 months. No? Hindi na pwede tapusin yung 1 year, 6 months plus 2. No? This is for the first offense, remaining period plus 2 years. Yung second, yung remaining period, example, 2 years. 2 years and a half na po. So 2 years and a half plus 2. Okay. If subsequent offenses. Okay. So ito yun, no? The GPPB makes it easier for us, no, to issue a blacklisting order. Ito lang, checklist lang. Ito lang, naka-check lang. Anong violation? Ito na. Okay. Okay. It is a downloadable form. No, nakasad na doon anong project, anong agency. No, nakasad na doon. So it's not it's easier for the HOPE or the appellate authority to issue the HOPE to issue blacklisting order. Okay. Ito yun, nakasad nun. And actually, it's already here in the form. It's already here. Sa online blacklisting portal, punta ka lang sa sa GPPB na website, then nandoon yung online blacklisting portal, no. So, electronic facility developed by GPPB TSO para ang mga procuring entity makapost doon ng blacklisting orders. So, doon yun ng mga blacklisted bidders. So, the blacklisting orders must be posted in the portal 3 calendar days from the date of its effectivity. Okay. In case of unlawful order from a judicial or in case of a lawful order, example, may mga restraining order or may yung mga appellate or court directing the temporary or permanently lift the period of suspension or remove the name of blacklisted entity from the consolidated blacklisting report, the PA through its official alternate user shall immediately remove the name of blacklisted entity upon receipt of the order. So dahil yung sa portal, dapat may isang official lang employee lang talaga na pwede maka-login doon. At saka isang alternate user. Just in case wala yung main. No? So the blacklisting entity shall only be qualified to participate in all procurement government procurement during a period of the temporary lifting or removal. No. Example, kung temporary example, TRO, 20 days for the regional trial court, so 20 days. After 20 days, balik na rin yung blacklisting kung walang permanent kung walang permanent restraining order. Okay. So dapat ma-adjust para lang ma-serve niyo yung 2 years or 1 year penalty.
And for the most awaited part, we will be having our last knowledge check question or what we call the prize question. So alam na natin siguro ang gagawin, no? So yung mga keyboard warrior, handa na po kayo. This time, we will be asking you to type in your answers to the Zoom chat box. The GPPBTSO will give a special token to the first participant who will answer the question correctly and of course, with the correct name format. Okay? So, may we ask our technical team to flash the question po? Okay, so let me read it. When does blacklisting order become final and executory? Is it letter A? If the bidder did not file a motion for reconsideration on the decision to suspend, said decision becomes final and executory after the lapse of 7 days counted from the receipt of the notice of the decision. Or letter B, if the bidder did not file a protest after his motion for reconsideration has been denied, the decision becomes final and executory after the lapse of 7 days counted from the receipt of the resolution on the motion for reconsideration. Letter C, if a protest was filed and the same was denied, the decision becomes final and executory upon receipt by the agency and person or entity concerned of the decision on the protest. Or letter D, all of the above. Okay? So, we're still accepting po your answer in the Zoom polling feature. But for our winner, before we announce po the winner, I will close the Zoom polling po para makita rin po natin yung majority answer ng ating participants. Okay? So I'll be closing in 5, 4, 3, 2, 1. Okay? So, Judge, based on our result po, most of the participants with 35% answered letter D, all of the above. Is this the correct answer po? I think you're still on mute. Okay, I'll be allowing you to unmute, sir.
Okay. So the answer is all of the above. No? All of the above. So if there's already a decision but the bidder or the blacklisted bidder did not file a motion for reconsideration within 70 calendar days, so after 7 calendar days, the decision becomes final and executory. An example, then, if he file a motion for reconsideration, but the same was denied, and still within 7 calendar days, wala po siya nag-appeal, then the same is final and executory. At saka nag-MR siya, denied, nag-file ng appeal, denied pa rin, then that is already final and executory. So the answer is all of the above.
All right, thank you po for the clarifications po, Judge Vitor. So at this time, allow me to announce our case winner based and upon the verification and validation of our technical team. We would like to congratulate po Ms. Susain Tesorero of MLGUS Oriental Mindoro for answering the correct answer. Okay, so I think Thank you very much po for our participants for actively participating in our polling questions. To our winners of special tokens, please check your messages and our event secretariat will contact you on how you may claim your prizes. And finally, that ends our discussion proper for today's learning session. Again, thank you, Judge Vitor, for a very exceptional discussion of protest mechanism and remedies and blacklisting guidelines po.
Good day to all.
All right, sir. So now, before we go to the most awaited open forum, please be reminded that questions which are initially gathered from the Zoom chat box and from our Facebook and YouTube live streaming comment sections are filtered, as our resource speaker shall only be answering questions related to our second learning session. Once again, may we invite our resource speaker to join us for this open forum. All right, sir. So I think ready na si sir to answer our gathered questions. Okay. May we request our technical team to flash the first question. Ayan po, while waiting for the questions, dun po sa ibang may mga pahabol pa po na clarifications, pwede niyo pong i-post pa rin ngayon since we still have para na enough time po for this for this open forum. So para maisama din po natin sa discussion and clarifications. Samantalahin na po natin habang nandito pa po ang ating resource speaker. Okay? So are we ready na po to our questions? Okay. For the first question, how can we...
Parang kanina lang yun
Oo nga po, ayan. So I think eto na po yung scenario po yung question, sir. Okay, so habang nagkakaroon tayo ng technical difficulties, as I've said, you can still po post your comment in our Zoom chat box, and for the Facebook Live viewers, you may still join po or raise your clarifications by putting your questions in the comment box section. Okay? Sir, baka ayan po pala, sorry, ayan na. So for the first question, is it allowed that the second-ranking bidders submit to the BAC a reconsideration of their decision regarding the decision of the BAC to grant the MR of one of the bidder which was ineligible during bid opening?
Ano po yun? Is it allowed? Hindi ko makita Is it
parang medyo
allowed
jumbled nga po yung
that the second-ranking bidder submit a BAC a reconsideration for the decision regarding the decision to grant the MR? Regarding the decision of the BAC to grant the MR of the one. Okay. So para mangyari dito, yung second ranking highest bid, lowest calculated bidder is asking for to file a reconsideration of their decision regarding the decision of the BAC to grant the MR of the one, ano ba, di kasi makita yung parang
one of the bidder po, sir.
Okay,
which is
parang
yung bidder daw po is ineligible during bid opening.
So, yung bid opening? Hindi po. And he's not a party to the case because it only involves that particular bidder. So kung mag-MR yung bidder, it's up for the BAC to decide. Kung i-deny pa rin yung protest, it's a protest, but I think it's protest, yeah. Kung i-deny pa rin it's not the BAC anymore, but it's the yeah. So he's not the second ranking bidder cannot file a motion for reconsideration for the BAC to deny the motion for consideration of that winning bidder or the one ineligible during the bid opening. Ano, hindi pwede yun. It's for the back to decide without any, dahil ano lang yun, ang nagpa-explain lang kasi yun yung ineligible during bid opening. So yun ang mag-MR, not the second ranking bidder.
All right, thank you po, Judge. So let's go to the next question. Does the issuance of a suspension to a bidder necessities proceeding to blacklisting?
Well, no. So the blacklisting only happen if there is already a probable cause to blacklist the bidder. So suspension is just an interim, no? Interim, kumbaga parang ano yan parang preventive suspension lang yan, no? Preventive suspension, but not a suspension itself dahil parang kwan lang yun interim lang. So it's not necessary that the suspension is that after the suspension there would be blacklisting. The procuring, the hope may found out that there is no ground for blacklisting. So the suspension should be lifted. No. So
All right. That is duly noted po. Let's proceed to the third question. Can an LGU permanently suspend a certain bidder from participating in future procurement if that bidder has incurred a 10% of liquidated damages from its contract price in the procurements of goods po siguro to, sir, particularly?
Okay. No, there is no such thing as permanent suspension. No, there is no such thing as permanent suspension because suspension is only an interim penalty in order to be blacklisted. You cannot, even in blacklisting, there is no permanent blacklisting because it's only up to 2 years. Then, if that bidder has incurred a 10%, more than 10% of liquidated damages, of course, you can also impose liquidated damages, but you cannot permanently suspend, no? Because suspension is just a precondition prior to blacklisting. And even if you already blacklisted that particular bidder, the blacklisting is only good for 1 year for the first offense or 2 years for the second offense. What you can permanently suspend, if you have to go to administrative provision, no, a person who actually committed the offenses as provided in that penal, civil, administrative codes, no, may administrative liability, then you can permanently suspend that private entity from participating in the bidding. But if the entity, you cannot suspend the entity because we know that the person is different person from the entity or for example from the corporation, di ba? So kung wala na yung tao, so permanently suspended yung tao, pero yung corporation hindi dahil blacklisted lang yun. So after 2 years. Walang permanent, again, there is no permanent suspension.
All right, thank you for that po. So let's move on to the fourth question. In case the respondent refuses to receive the show cause order, what will be our course of action? What will be our reckoning date for our succeeding legal action? And do you have standard formats of showcase order and decision?
Well, if refuse to receive, sa court, ang ginagawa lang namin is just yung tinatawag namin tender. No? Ibigay sa kanya yung show cause order. Pag ayaw niya receive, okay lang. Just give a copy. Sabihin mo, just receive the copy. I will not force you to receive it. No, I will just take note that you refuse to receive the order. No. Now, in that particular case, that's the reckoning date, no, na na-receive po niya yung show cause order. Kung kung within the time frame na binigay to give a show cause order, hindi siya magsasubmit despite that receipt, di ba? The one who served the show cause order should take note that Mr. So and so refused to receive the show cause order, but the undersigned gave a copy to this person. No? So yun lang. Pag ayaw niya, then you have to decide based on the verified findings that there's a ground to blacklist that particular bidder. So as to the standard, well, it's up. Iwan ko sa. Well, there is no standard as far as I know, but it's up for the GPPB to you know. Well, I think I provided you also the format. The format, di ba? Ano yun na project at saka ground, then a reason why you should not be blacklisted. So that's a show cause order. Why you should not be blacklisted? Because you committed this particular offenses, then why you should not be suspended or blacklisted. So that's already a show cause order. So the show cause, the other party, the bidder, will already answer on why it cannot be suspended or blacklisted. So that's already a show cause order. I already presented to you the format, but not the form as in toto, that just like the blacklisting order that you have just checked which probation that or grounds na blacklist po siya. So yun lang, again, kung refuse po siya mag-receive, just tender the order. Then the server should take note that the party refused to receive the order, but you still give a copy to that person. No? Kahit hindi mo ipa-receive yung order. Then the reckoning date, yung pag-receive po niya, that's already the reckoning date of the period to submit show cause. Then there is a format already. I've shown to you already the format, the show cause order. But not the standard, just like the blacklisting order na naka-checklist lang. No? Okay, that's all.
All right. Thank you po for a very comprehensive explanation. And I believe that was our last question. So if you have more questions, you may still ask our resource speakers by visiting slido.com. All you have to do is to just type in the event code #government procurement PH, to which the GPPTSO will answer through an issuance or